Hello, everybody. Welcome back to Law, Liberty, and Logic. Today, I wanted to go over something kind of interesting. The Corporate Transparency Act is an act that seeks to regulate private corporations in the United States that are constructed at the state level. And the United States District Court for the Eastern District of Texas actually put an injunction on the CTA across the entire United States. And this is a very touchy subject because the federal government is attempting to spy on every single person who has a corporation, essentially in the US, who has a small corporation. There are some exceptions and things like that, but it's a very concerning invasion of privacy and a major collection of data. So I'm not going to get into all the core details right off the cuff. I'm going to focus on reading through this case. And as it goes through, I'll discuss different things and kind of give you a sense of what's going on. So if you're watching this and maybe you have a corporation or you've just been curious about this, you've heard about it and you're concerned about privacy issues and First Amendment issues, this video will help elaborate on this case and talk about what's going on in the next steps. It's not, of course, legal advice. This is just for informational purposes only, but it'll be a fun way to look at this and see what some possibilities are in terms of outcomes. So as you can see here, it was the Texas Top Cop Shop Incorporated, and then there's other parties against MERRICK GARLAND, Attorney General of the United States. So it was a civil action. And, in the result of this, after their case, the judge entered in an order. And so I'm going to read through this and we'll get a sense of what's happening. Pending before the court is plaintiff's motion for preliminary injunction. Through it, plaintiffs seek to enjoin the government from enforcing the Corporate Transparency Act and its implementing regulations. Having considered the motion, the arguments of counsel, and the applicable law, the court concludes that the motion should be granted. So in other words, this motion here is going to be in favor of those plaintiffs for the preliminary injunction. And the preliminary injunction means that it's not able to be enforced for now. So this law, at least for now, is not able to be enforced, but we'll talk more about what might come up later. So it says, great nations like great men should keep their word. Federal Power Communications versus Tuscarora Indian Nation. So they're just having a little quote here at the beginning. It says, ours is a written constitution. The promises it makes to the people and the states alike are not hidden. The court must enforce them. The powers of the legislature are defined and limited, and those limits may not be mistaken or forgotten. The Constitution is written, from Marbury versus Madison, a very big landmark case. So what they're kind of laying out here is that the federal government is limited. It's not supposed to just be able to do anything willy-nilly. There are specific restrictions, and that is what this case is going to revolve around, is how far can the federal power go as relates to state-created corporations. While the court defers to Congress on matters of policy, interpretation of the Constitution is an area where Congress enjoys no authority. Right? Of course, Supreme Courts and the lower courts, they're the ones who interpret the Constitution. Congress just makes the laws. It is not for the court to substitute its view of policy for the legislation which has been passed by Congress as well. They noted that from Marbury, just saying there that the Supreme Court is not supposed to reinterpret the laws and just make up laws themselves. They're also supposed to just be limited in terms of just saying what the law is if there's any ambiguity. Legislative ingenuity dispatched to meet today's problems is not measured by any other standard than our written constitution. Modern problems may well warrant modern solutions, but modernity does not grant Congress a roving license to legislate outside the boundaries of our timeless written constitution. So the court here is just reiterating that, yes, there could be changes in social circumstances. There'd be changes in different things and technologies and other things that might present new problems, but the government is still supposed to be limited, and the Constitution provides a backdrop to that limit. And they say here the Constitution must stand firm. In the matter before the court, plaintiffs challenge an unprecedented law known as the Corporate Transparency Act. It represents Congress's attempt to combat bad actors' ability to cloak their criminal activities in a veil of corporate anonymity. At its most rudimentary level, the CTA regulates companies that are registered to do business under a state's law, and requires those companies to report their ownership, including detailed personal information about their owners, to the federal government on pain of severe penalties. And just having, seen this up close, they're asking specifically for who is a beneficial owner. So they, say that someone who has 25% or more interest in the company to get that level of benefit. And they're asking for things like a personal identification. So it could be a passport or a driver's license that you submit. So it's pretty invasive, especially if you are someone who had anonymous corporations. So that's why this is a big deal. Though seemingly benign, this federal mandate marks a drastic twofold departure from history. First, it represents a federal attempt to monitor companies created under state law, a matter our federalist system left almost exclusively to several states. So the court here is just pointing out that corporate fictions are a creature of the 50 states. It's not the federal government's purview to go and regulate and monitor these things. And, what they're asking for is just purely information. So the federal government here is just asking purely just for people to report and say, if you don't give us information, then we can fine you. And of course, fines are really threats of arrest and even death if you refuse. So it's a pretty big deal. Second, the CTA ends a feature of corporate formation as designed by various states, anonymity, right? And so if you want to create an anonymous corporation for very, good reasons, the federal government is trying to upend that. For good reason, plaintiffs fear this flanking quasi-Orwellian statute and its implications on our dual system of government. And it's really interesting to see this court here say Orwellian to point out the level of intrusion and how much spying power this gives the government on top of what they already have. Obviously with the NSA and other things, this is a next level of trying to circumvent people protecting themselves. As a result, plaintiffs contend that the CTA violates the promises of our Constitution, makes the people that the promises of our Constitution makes the people in the states. Despite attempting to reconcile the CTA with the Constitution at every turn, the government is unable to provide the court with any tenable theory that the CTA falls within Congress's power. And even in the face of the deference the court must give Congress, the CTA appears likely unconstitutional. So notice here that they're framing this as this is likely unconstitutional because they're not striking it down. They're just giving a preliminary injunction, right? So they're just saying, hey, you can't enforce this yet. We haven't ruled that this is totally unconstitutional fully yet. But as a court, this is so seemingly unconstitutional, we're willing to give this an injunction, say, no, you can't enforce this law. Accordingly, the CTA and its implementing regulations must be enjoined. So that's an injunction. So now they're going to get into the background here, which will give you a bit more detail about the Corporate Transparency Act. This case begins and ends with the CTA. The constitutionality of the CTA and its accompanying regulations is an issue of first impression in the Fifth Circuit. So this is the first time that they're seeing this. Thus, this case necessitates a robust explanation of the CTA. So what's good about this case in terms of us talking about it here is that you're going to get more details about what's going on with it and its history. In January of 2021, Congress passed the William M. Mac Thornberry National Defense Authorization Act for fiscal year 2021, also known as the NDAA, which the NDAA, if you're not already familiar, always comes with lots of infringements on people's liberty because it's used to circumvent the First and Fourth Amendments. Congress included the Anti-Money Laundering Act of 2020 in the NDAA. The AMLA's stated purposes are many. First, through the AMLA, Congress sought to improve coordination and information sharing among the agencies tasked with administering anti-money laundering requirements. Second, in passing the AMLA, Congress sought to modernize anti-money laundering and counterfeiting the financing of terrorism laws. Third, the AMLA seeks to encourage technological innovation and the adoption of new technology by financial institutions to more effectively counter money laundering and the financing of terrorism. Fourth, Congress designed the AMLA to reinforce that the anti-money laundering and terrorism financing policies, procedures, and controls of financial institutions shall be risk-based. Fifth, and most importantly, as it relates to the CTA, Congress intended the AMLA to establish uniform beneficial ownership information reporting requirements to further four ends: transparency concerning corporate structures and insight into the flow of illicit funds to the structures, discouraging the use of shell corporations as a tool to disguise and move illicit funds, assisting national security intelligence and law enforcement with the pursuit of crimes, and 4, protecting the national security of the United States. The 6th and final stated purpose of the AMLA is to establish a secure, non-public database at FinCEN for beneficial ownership information. And so, as you can see here, the databasing here is with the is with FinCEN. That's that financial crimes unit within the federal government. So that's where this information gets submitted to. Nestled between the 1,482 pages of the NDAA, so as you could see, that was quite the crony bill, having nearly 1,500 pages, lays the CTA. In short, the CTA requires a vast array of companies to disclose otherwise private stakeholder information to FinCEN. Congress compels these disclosures to control financial crime. Indeed, the CTA says as much. Because text reigns supreme in statutory interpretation, rather than summarize the CTA's purpose, it is wiser to grasp the CTA's objectives from its plain text. The CTA provides that it is the sense of Congress that, and here's our specific statements, more than 2 million corporations and limited liability companies are being formed under the laws of the states each year. Most or all states do not require information about the beneficial owners of the corporations, limited liability companies, or other similar entities formed under the laws of the state. Malign actors seek to conceal their ownership of corporations, limited liability companies, and other similar entities in the United States to facilitate illegal activity or illicit activity, including money laundering, the financing of terrorism, proliferation financing, serious tax fraud, human and drug trafficking, counterfeiting, piracy, securities fraud, financial fraud, and acts of foreign corruption harming the national security interests of the United States and the allies of the United States. And lastly here, it's not lastly, it's number 4. Money launderers and others involved in commercial activity intentionally conduct transactions through corporate structures in order to evade detection and may layer such structures, much like Russian nesting Matryoshka dolls, across various secretive jurisdictions, such that each time an investigator obtains ownership records for a domestic or foreign entity, the newly identified entity is yet another corporate entity, necessitating a repeat of the same process. Federal legislation providing for the collection of beneficial ownership information for corporations, limited liability companies, or other similar entities formed under the laws of states is needed to set a clear federal standard for incorporation practices, protect vital United States national security interests, protect interstate and foreign commerce, better enable critical national security, intelligence, and law enforcement efforts to counter money laundering and the financing of terrorism and other illicit activity, and bring the United States into compliance with international anti-money laundering and counterfeiting the financing of terrorism standards. Countering the financing of terrorism standards. Now, lastly, beneficial ownership information collected under the amendments made by this title is sensitive information and will be directly available only to authorized government authorities, subject to effective safeguards and controls to facilitate important national security, intelligence, law enforcement activities, and confirm beneficial ownership information provided to financial institutions to facilitate the compliance of the financial institutions with anti-money laundering, countering the financing of terrorism, and customer due diligence requirements under applicable law. So as you can see, the government tries to couch this all as, no, we're just going after bad guys. We're going after terrorists. And as you may know, the government always uses those pretexts to infringe on individuals' liberty and privacy. They always try to use boogeymen to then go after regular people for political purposes, which is, of course, of concern here. In service of these admirable ends, the CTA regulates reporting companies. Under the CTA, a reporting company is a corporation, limited liability company, or other similar entity that is created by the filing of a document with the Secretary of State or similar office under the law of a state or Indian tribe, or formed under the law of a foreign country and registered to do business in the United States by the filing of a document with the Secretary of State or similar office under the law of a state or Indian tribe. And of course, there's a lot of corporations because lots of people use corporations for all kinds of benign things. The CTA's text excludes from the definition of reporting companies several types of entities, including but not limited to political organizations, as defined in a certain section of the Revenue Code. These reporting companies must submit to FinCEN a report that identifies each beneficial owner of the reporting company by full legal name, date of birth, current residential or business street address, and a unique identifying number from an acceptable identification document or FinCEN identifier. So, it's kind of interesting here that they want you to do all this, and yet they do exempt certain organizations, right? Notice how they exempted the political ones. Funnily enough, right? They don't they want to cover everybody else, but why would these politicians want to exempt the political organizations? Maybe because they want to cover themselves. I can imagine. So the CTA defines the term beneficial owner as an individual who directly or indirectly through any contract, arrangement, understanding, relationship, or otherwise exercises substantial control over the entity or owns or controls not less than 25% of the ownership interest of the entity. So as you can see, this gets very tricky because, okay, how do you figure out if you're a beneficial owner? Okay, well, there's a lot of ways that you can suddenly become a beneficial owner, even if maybe you're not actually a listed owner. The CTA accepts from beneficial owner status those who are minors, persons acting on behalf of another individual, such as agents and custodians, employees, those whose only interest in the company is through right of inheritance, and creditors. In turn, an acceptable identification document is a non-expired U.S. passport, identification document issued by a state, local government, Indian tribe for purposes of identification, driver's license issued by a state, or a passport issued by a foreign government. But the individual in question doesn't have any of the previous forms of identification. I'm going to take a drink of water here. Okay. So as I was mentioning before, they're getting your personally, identifying documentation. They're collecting and associating this with serious stuff, passport, driver's license, right? So they're putting together all these things and collecting this data about you, for being a beneficial owner of a corporation, and then just hand it over to the government and saying, okay, here's our way of being able to track different people. The term unique identifying number refers to the unique identifying number from an acceptable identification document, i.e. a passport number and the like. Finally, while the CTA itself does not define substantial control, the final rule implementing the CTA, the reporting rule, does. Under the reporting rule, substantial control means serving as a senior officer of the reporting company, having authority to hire and fire senior officers, the majority of the board of directors or a similar body, or directing, determining, or having substantial influence over important decisions made by the reporting company. And as you can hear with number 3, that's where it gets kind of tricky, right? Because it's not just, oh, you're an actual listed board member or you're a listed manager or you're a listed owner. Oh, you have substantial influence. Okay, well, what does that mean? Further, any other form of substantial control over the reporting company constitutes substantial control under the reporting rule, be it direct or indirect. Wow. So at what point, are they considering someone's just pure influence, right? You're not actually on the corporate documents, but you have substantial influence. So what, that gets really tricky and iffy there. The CTA delegates authority to the Secretary of the Treasury to establish an effective date for filing and updating beneficial ownership information reports and to promulgate regulations regarding these reports. Pursuant to that authority, FinCEN's regulations state that any domestic reporting company created before January 1st, 2024, and any entity that became a foreign reporting company before January 1st, 2024 shall file a report not later than January 1st, 2025. So that's why there's such a pressing issue for many people is there's a lot of companies, I think it's something like 30 million at least, that had until January 1st, 2025, roughly a year to comply with this. So reports of beneficial ownership information, I read that right. The remainder of FinCEN's regulations give teeth to the CTA as codified. Under the reporting rule, the content of a reporting company's beneficial owner report must include the legal name of the company's trade names, the address of its principal place of business or primary location in the United States, the state, tribal, or foreign jurisdiction of the company's formation, and the company's internal revenue services taxpayer ID, right? So we're talking associating taxpayer ID, personal identification, the corporate information. It's a big stack of identifying information that is, kind of scary to have all together at once, especially with the government. Further, the report must include the full legal name of each beneficial owner of the company, their date of birth, their business or residential address, their unique identifying number for an approved identification document, and a photograph of that document, right? So you have to scan it in or take a picture of it. Covered entities have a continuing obligation to update their beneficial owner reports. So that's also kind of a crazy thing is it's like, okay, you file first, but then over time, what happens? What if someone's a beneficial owner suddenly in the midst of things and then they're not? Like how does that fluctuate, right? FinCEN shall maintain this information for at least 5 years after the date on which the reporting company terminates. So they even keep it for 5 years after you close. The CTA permits FinCEN to disclose any beneficial ownership information upon request from state, local, federal, or international law enforcement entities. That's actually extra scary, right? It's not just that they have it, but they can disclose it to all kinds of levels of federal, state, local government in the US and international. They can literally take your stuff and send it to international. Again, when you're talking about political threats, in other words, whoever's in power maybe doesn't like you for some reason, and they want to go after you, they want to do something bad against you. This puts together a very easy package. The CTA also mandates that FinCEN take certain precautions with the beneficial ownership information to avoid inappropriate disclosure of that information. This is where it gets really scary, right? Failure to comply with the CTA is fraught with peril. The CTA makes it illegal to willfully provide or attempt to provide false or fraudulent beneficial ownership information and willfully fail to report, complete, or update beneficial ownership information. Any individual who is guilty of violating either provision is civilly liable and may be fined up to $500 a day for each day that the violation continues or has not been remedied, right? So $500 a day, that's a lot of money. Further, any individual who is guilty of violating either provision may be incarcerated for up to 2 years and fined up to $10,000. Wow. So you could be imprisoned, you could have a huge fine just levied against you as a base of $10,000, and you get an extra $500 a day fine. That's very threatening over filing some documentation and having to deal with the ambiguities of who's a beneficial owner and, do they have enough influence, even if they're not actually a director, even if they're not on the board, even if they're not a manager. Scary stuff. The CTA also prescribes unauthorized disclosure of beneficial ownership information and subjects any person who knowingly discloses such information without authorization of criminal and civil penalties. Like that matters for the government. The government doesn't care about prosecuting themselves. So, according to FinCEN, the CTA will have a significant economic impact on a substantial number of small entities. Beneficial ownership information reporting requirements are going to there's an estimate by FinCEN that there will be approximately 32.6 million existing reporting companies and 5 million new reporting companies formed each year. That's a lot of companies. Assuming that all reporting companies are small businesses, the burden hours for filing the BOI reports would be 126.3 million in the first year of the reporting requirement as existing small businesses come into compliance with the rule, and 35 million in the years after. FinCEN estimates the total cost of BOI filing reports is approximately 22.7 billion in the first year and 5.6 billion in the years after. So keep in mind, not only is this an invasion of privacy, but the compliance costs, especially if someone's like, okay, I got to meet with an accountant, I got to meet with an attorney, and I have to deal with this novel thing on top of everything else. Now it's costing me extra billable hours to make sure, okay, are we in compliance? Otherwise, I'm going to go to jail. That's a lot of compliance costs. That's costing people a lot of money just to submit paperwork so the government can spy on people. Right? I mean, it's a huge waste, a huge burden on the economy over nothing. And again, they're not even saying that you're being accused of a crime, right? This is not, you're being accused of a crime. It's just we want all the data right off the cuff with nothing more. FinCEN estimates it will cost $85.14 to $2,614.87. So in other words, $85 to $2,500 roughly each to prepare and submit an initial report for the first year that the BOI reporting requirements are in effect. Finally, FinCEN estimates it would cost approximately $37 to $560 roughly for entities to file updated BOI reports. According to FinCEN, these estimates include professional expertise that will be sought out to comply with their reporting requirements, such as lawyers and accountants. So they're forcing this expense on over 30 million different businesses and adding on costs for just regulatory red tape that is not itself actually an accusation that anyone did a crime. It's just, pre-crime. We're going to accuse everybody as if you are criminal and force you to comply under the threat of being locked up. All right, let's get to the parties. There are 6 plaintiffs in this case comprised of 1 private individual and 5 entities. First, Texas Top Cop Shop Incorporated is a family-run Texas corporation that maintains its principal place of business and all of its corporations in Conroe, Texas. Since 2017, TTCS has sold equipment to first responders out of its single storefront in Conroe. I hope I'm saying that right. I'm not sure, but never heard of that place before. It looks like Conroe. In addition, TTCS is a licensed dealer of firearms. TTCS does not transact any business through the internet, nor does it sell its merchandise outside of Texas. That's an important factor, right? Because they can't even claim that it's interstate commerce here, right, for federal purposes, if all they do is literally deal in one state. So, only 4 employees, including the owners, work at TTCS. Through TTCS, though TTCS has determined on its own that it is a reporting company under the CTA, to date, it has not filed the beneficial ownership report with FinCEN. So they didn't file it. They're going to sue over this. And it sounds like they're a good plaintiff for this because they have, money to do so. They have a couple of companies at risk. And on top of that, they have a really good case that they don't even engage in interstate commerce. So makes it extra interesting with the feds trying to regulate something they have no business dealing with at all. All right, the second plaintiff, Datacom for Business Incorporated, is a Delaware corporation that operates both in Illinois and Texas. It is also registered with the Illinois Secretary of State to engage in business as a foreign corporation. Datacom provides small businesses, individuals, utility companies, and federal agencies with technical support, information technology, and communications products, and employs 10 individuals. Like TTCS, while Datacom has determined that it is a reporting company subject to the CTA's disclosure requirements, it has yet to file a BOI with FinCEN. Further, Datacom advocates for the appeal of the CTA as a corporation to protect the privacy of its beneficial owners. So that's good to see there, too. They're talking about the privacy aspect. The third plaintiff, Russell Strayer, is an individual who resides in Conroe, Texas, and is closely tied to Datacom, the company for which he serves as chief executive officer. He has determined that he is a beneficial owner of Datacom, though he is not the only beneficial owner of Datacom. Strayer claims that he is a beneficial owner of additional reporting companies not involved in this case. Though Strayer is an outspoken opponent of the CTA, one of the reporting companies of which Strayer is a beneficial owner does not wish to be associated with his position against the CTA. Strayer has not filed a report with FinCEN. The fourth plaintiff is Mustard Seed Livestock, LLC. Mustard Seed is a Wyoming limited liability company that has operated a small dairy farm exclusively in Lingle, Wyoming since 2020. It does not transact interstate business. While it generally produces dairy products for its own use, it occasionally sells surplus raw milk to Wyoming customers. In 2023, Mustard Seed's gross income from surplus milk sales did not exceed $30,000, and its projected income from all offerings will not exceed $50,000. Though it is determined that as a reporting company of the CTA, to date it has not filed a beneficial ownership report. Like Datacom, Mustard Seed advocates the repeal of the CTA as a corporate entity to protect its beneficial owners' privacy. The fifth plaintiff is the Libertarian Party of Mississippi. MSLP dubs itself a political organization, though it notes that it is not classified as such under Section 527 of the Internal Revenue Code. Therefore, by its own admission, it is a reporting company under the CTA. MSLP is organized under Mississippi law and is registered with the Mississippi Secretary of State as a nonprofit corporation. It has no physical office. Instead, it relies on its members to conduct its activities. Members of MSLP seek to advance the platform of the National Libertarian Party within the state of Mississippi. Thus, MSLP and its members advocate for a plethora of positions on political issues and ideals. One such issue is the CTA, which MSLP advocates against. Because it operates as a political organization, individuals and entities alike donate to MSLP. In turn, MSLP uses those donations to promote its political agendas. MSLP has less than $20,000 in assets, which are the product of donations and used only for political expenditures. None of these expenditures promote activities out of the state of Mississippi, and MSLP does not engage in any economic activity outside of Mississippi. Like its co-plaintiffs, MSLP has not filed a beneficial owner report with FinCEN. The sixth and final plaintiff, the National Federation of Independent Business, NFIB, is distinct from its co-plaintiffs in that it is an organization suing on behalf of its members who are not a party to this lawsuit. NFIB is a tax-exempt organization under Section 501C of the Internal Revenue Code. Thus, the CTA does not compel it to file a report with FinCEN. Approximately 300,000 members comprise NFIB, and TTCS and Datacom, both of which are plaintiffs here, are members of NFIB. NFIB also notes that its members include companies like Grazing Systems Supply Incorporated, a Louisiana corporation with its principal place of business in Batesville, Indiana. Grazing Systems Supply is a family-run agricultural supply business with 5 employees that must comply with the CTA. NFIB and its members advocate against the CTA, and NFIB has publicly argued for its repeal on behalf of its members. None of the 5 individual plaintiffs here have filed beneficial ownership reports with FinCEN. Further, each plaintiff claims that if enforcement of the CTA is not enjoined, plaintiffs' obligations to the CTA would compel them to incur compliance costs and would violate their constitutional rights. And I agree. Defendants are comprised of several United States representatives and the governmental entities they serve. First, defendant MERRICK GARLAND is the United States Attorney General, who plaintiffs sue in his official capacity, as he is responsible for the administration and enforcement of United States federal criminal law according to the CTA. Second, defendant Janet L. Yellen is the United States Secretary of Treasury, who plaintiffs sue in her official capacity as the head of the U.S. Department of the Treasury. Plaintiffs also sue defendant U.S. Department of the Treasury, an agency under the executive branch that administers and enforces the CTA and its accompanying regulations. Fourth, defendant Andrea Gacki is the director of FinCEN, who plaintiffs sue in her official capacity as the head of FinCEN. Finally, plaintiffs sue defendants FinCEN as a bureau of a federal agency that administers and enforces the CTA and its implementing regulations. Collectively, the court defers to defendants as the government, which, yeah, that makes sense. All right, procedural history. This is where we get to how things came about in the courts. On May 28, 2024, plaintiffs initiated this lawsuit seeking a declaratory judgment that the CTA is unconstitutional and an injunction against its enforcement. On June 3rd, 2024, plaintiffs moved the court to enter a preliminary injunction against enforcement of the CTA and the reporting rule. On June 26, 2024, defendants responded opposing the issuance of any injunctive relief. Plaintiffs replied, maintaining that preliminary injunction is warranted. On September 24, 2024, defendants notified the court of supplemental persuasive authority. After the court set its matter for a hearing, the parties jointly filed stipulations that negated the need to call witnesses at the hearing. On October 9, 2024, the court heard the arguments of counsel. Finally, on October 24, 2024, defendants notified the court of further supplemental persuasive authority. So basically, they got all their arguments and their cases together. All right, so now this is the legal standard. So this is how come they're saying a preliminary injunction is right here in terms of something that could be possibly used. A preliminary injunction is an extraordinary remedy never awarded as of right. In other words, you have to merit it. A party seeking a preliminary injunction must establish 4 elements. 1, a substantial likelihood of success in the merits. 2, a substantial threat that they will suffer irreparable harm absent injunctive relief. 3, that the threatened injury outweighs any damage that the injunction might cause a defendant. And 4, that the injunction will not harm the public interest. A preliminary injunction should only be granted if the plaintiffs have clearly carried the burden of persuasion in all 4 requirements. So they have to, meet each of these elements. Nevertheless, a movement is not required to prove his case in full at a preliminary injunction hearing. So this is how come they said, at the beginning that, they likely think they would win on the merits. It seems unconstitutional, but they don't have to go through the fullness of the case because it's just for the injunction. The decision of whether to grant a preliminary injunction lies with the sound discretion of the district court. All right, so here's the analysis. We get to the meat. Why was this injunction granted? Plaintiffs challenge the CTA on several grounds. Namely, plaintiffs assert that the CTA is unconstitutional both facially and as applied because, 1, the CTA intrudes upon states' rights under the 9th and 10th Amendments. So remember, the 9th and 10th Amendments say that basically any powers that were not delegated to the federal government are reserved to the people and the states respectively. And just from a constitutional perspective, the federal government is not unlimited. And if they're not expressly given things, it is not supposed to be in their purview just to say we can do whatever we want. 2, the CTA compels speech and burdens plaintiffs' right of association of the First Amendment. And 3, the CTA violates the Fourth Amendment by compelling disclosure of private information. So these are some serious legal issues. This is really talking about both big constitutional issues, 9th and 10th Amendment issues that don't often get brought up, especially at the Supreme Court. I know Thomas might be interested in that. And the Fourth Amendment part, I think, is very serious because it is clearly disclosure of private information. It's not with a warrant. It's not with a claim of anyone doing a criminal activity. So it's a pretty big deal. For each of these reasons, independently, collectively, plaintiffs assert that FinCEN's reporting rule, which implements the CTA, is also unconstitutional and should be set aside under 706 of the Administrative Procedure Act. Whether the CTA and the reporting rule are absolutely unconstitutional is a question for another day, right? So as we talked about before, injunction, not dealing with the final ruling, just whether it's so likely that this person would win, probably that we can stop the enforcement for now. Today is enough for the court to determine whether the plaintiffs have demonstrated a substantial likelihood of success in the merits of any of their claims, in addition to satisfying the 3 additional elements necessary for preliminary injunction. Before the court can reach the merits of the plaintiff's arguments, it must dispense with 2 threshold matters. Namely, the court must perform a dual-pronged standing inquiry. First, it must assess whether the individual plaintiffs have standing. Second, the court must ensure that NFIB has associational standing to participate in this litigation on behalf of its members. So remember, with any court case, one of the first things you need to show is jurisdiction and standing. You got to show that the court has jurisdictional rights over, dealing with the matter, and that the people who are seeking relief have the association rights to be able to seek it in that specific venue, right? Standing. A preliminary injunction like final relief cannot be requested by a plaintiff who lacks standing to sue. Though defendants do not contest that plaintiffs have standing, it is well established that the court has an independent obligation to assure that standing exists, regardless of whether it's challenged by any of the parties. So even by doing this process, it's kind of useful to the final disposition later on when they actually go on the merits, because just showing, hey, yes, they have standing to sue is a big deal. A lot of political issues get dismissed on standing issues. So here, plaintiffs consist of both individuals and association. While an individual standing is an independent legal inquiry, whether an organization is standing hinges in part on whether its members alone would have standing. Because 2 of the individual plaintiffs here are members of NFIB, the associational standing inquiry builds off the individual standing assessment to some extent. Thus, the court will first ask whether each individual plaintiff has standing. Then the court will assess whether NFIB has standing. For the reasons that follow, the court concludes that every plaintiff has standing, which, should be pretty clear, especially because a lot of these people are actually headquartered in Texas, right? Oh, there you go. And obviously it's going to affect them. The law is definitely affecting them. Federal courts are courts of limited jurisdiction. They possess only that power authorized by Constitution and statute. Article 3 of the United States Constitution mandates that federal courts may only hear cases and controversies. The doctrine of standing gives meaning to these constitutional limits by identifying those disputes which are appropriately resolved through the judicial process. Thus, Article 3 standing is a bedrock constitutional requirement. Matter is only justiciable if a plaintiff establishes every element of standing. To establish standing, an individual plaintiff must satisfy the familiar 3-part test under Article 3. The plaintiffs must have 1, suffered an injury in fact, 2, that is fairly traceable to the challenged conduct of the defendant, and 3, that is likely to be redressed by a favorable judicial decision. These requirements constitute an essential and unchanging part of the case or controversy requirement of Article 3. The party invoking federal jurisdiction carries the burden of establishing that they have standing. Because the elements of standing are not mere pleading requirements, but rather an indispensable part of the plaintiff's case, each element must be supported with the manner and degree of evidence required at the successive stages of litigation. So in other words, you basically have to meet each of these prongs if it's a civil case, right, by preponderance of the evidence, which is a lower standard, of course, in criminal where it's, beyond a reasonable doubt. A court may only issue a preliminary injunction if the plaintiff makes a clear showing that the plaintiff is entitled to such relief. Thus, at this stage, plaintiffs must make a clear showing of standing to maintain the injunction. And plaintiffs here have met that burden, unsurprisingly. Injury in fact. The first element of standing is an injury in fact. An alleged injury must meet 3 requirements to constitute an injury in fact. First, the injury must be concrete, meaning that it must be real and not abstract. Second, the injury must be particularized. That is, the injury must affect the plaintiff in a personal, individual way and not be a generalized grievance. To demonstrate, the Supreme Court has noted that an injury in fact can be a physical injury, a monetary injury, an injury to one's property, or an injury to one's constitutional rights, to take a few common examples. Third and finally, the injury must be actual or imminent, not speculative, meaning that the injury must have already occurred or be likely to soon occur. In cases such as this one, when a plaintiff seeks prospective relief, such as an injunction, the plaintiff must establish a sufficient likelihood of future injury. With this in mind, a plaintiff may challenge a federal statute before it has been enforced if they can demonstrate a realistic danger of sustaining a direct injury from the federal statute's enforcement. This rule makes sense as certainly Article 3 standing requirements do not require a plaintiff to expose himself to actual arrest or prosecution to be entitled to challenge. That is the statute, which is good because it'd be bad if the only way you could challenge it is first you have to be harmed or be arrested, right? That would really stink. You want to sue before you actually get harmed if possible. Thus, in cases involving pre-enforcement challenges, a plaintiff satisfies the injury in fact requirement if they intend to engage in a course of conduct arguably affected with a constitutional interest, but prescribed by statute. and there exists a credible threat of prosecution thereunder. Independently, an increased regulatory burden typically satisfies the injury in fact requirement. As the Fifth Circuit has recognized, where a new rule requires at least some degree of preparatory analysis, staff training, and reviews of existing compliance protocols, the injury in fact requirement is satisfied. This too makes sense, as these are precisely the types of concrete injuries that the Fifth Circuit has consistently deemed adequate to provide standing and regulatory challenges. Here, each of the 5 individual plaintiffs had met their burden to satisfy the injury in fact requirement for 2 reasons. First, plaintiffs' complaint and declarations show that they intend to engage in a course of conduct arguably affected with a constitutional interest, but prescribed by statute. Specifically, each individual plaintiff has not filed a beneficial ownership information report with FinCEN and refuses to file such a report absent a judicial declaration that they must comply with the CTA. Plaintiffs recognize that the CTA compels them to tender a BOI report to FinCEN. Nonetheless, plaintiffs refuse to do so because they contend the CTA violates their rights under the 1st, 4th, 9th, and 10th Amendments to the United States Constitution, which those are quite a few amendments to be suing under. So that's a lot of opportunities for striking something down. The parties agree that plaintiffs' intended course of action subjects plaintiffs to criminal and civil liability under the CTA. There's no doubt the CTA will be applied with its full force. It is axiomatic the government does not defend the CTA in this litigation simply for the sake of litigating. The CTA and its implementing regulations would be aspirational were it not for its robust penalty provisions. Thus, the plaintiff's fear of prosecution is not imaginary or wholly speculative. Accordingly, plaintiffs have clearly established an injury in fact sufficient to satisfy this prong of a standing injury. Second, the CTA's enforcement require plaintiffs to incur increased regulatory burdens, which alone are sufficient to confer standing. The CTA and reporting rule by FinCEN's own admission will cause reporting companies to incur at least some compliance costs. FinCEN estimates that it'll cost the majority of the 32.6 million domestic and foreign reporting companies that are estimated to exist as the January 2024 effective date approximately $85 a piece to prepare and submit an initial BOI report. FinCEN also estimates it'll take approximately 20 minutes to read a beneficial ownership report form and understand it, 30 minutes to collect information about companies' beneficial owners, and 20 minutes to fill out and file the report, resulting in a 70-minute endeavor. FinCEN acknowledges, however, that the more complex the reporting company structure, the greater the costs. According to FinCEN, more complicated reporting companies may take at least 650 minutes to file a report and incur approximately $2,614 in compliance costs. Here, plaintiffs confirm that they will incur such compliance costs, among others, that the CTA and reporting rule are not enjoined. These costs are precisely the types of concrete injuries that the Fifth Circuit has consistently deemed adequate to provide standing and regulatory challenges. Thus, plaintiffs have satisfied the injury in fact requirement because of the increased regulatory burden that the CTA and the reporting rule imposes on plaintiffs. So, key fact to take away, regulatory burdens, where it shows that you could have costs from it, is an injury in fact for that prong. All right, causation and redressability. The second and third elements of standing, causation and redressability, are often flip sides of the same coin. If a defendant's actions causes an injury and joining the action or awarding damages for the action will typically redress that injury. In cases such as this one, where plaintiffs sue the government seeking relief from one of its regulations, these two elements are easy to establish. Indeed, government regulations that require or forbid some action by the plaintiff almost invariably satisfy the causation requirement. Because the government statute, the CTA, and regulation reporting rule aggrieve plaintiffs, and because the court's relief may redress plaintiffs' alleged injuries, plaintiffs have satisfied Article 3's causation and redressability requirements. Accordingly, the individual plaintiffs here are standing to bring the instant lawsuit. So, obviously, if you stop the enforcement, that would redress the issue because you'd no longer be facing fines and be potentially jailed. So, pretty straightforward. Yes, you can get redress if you get the enforcement stopped. All right, associational standing. Having determined that the individual plaintiffs in this lawsuit are standing, the court now turns to the issue of whether NFIB has associational standing, such that it may partake in this litigation on behalf of its members. As both the Supreme Court and Fifth Circuit have recognized, an association such as NFIB has standing to sue on behalf of its members when 3 elements are satisfied. First, the association's members must independently meet Article 3 standing requirements. Second, the interests the association seeks to protect must be germane to the organization's purpose. Third, neither the claim asserted nor the relief requested may require the participation of individual members in the lawsuit. Here, all three elements are obviously satisfied because they're protecting their members who actually fall under this, and doing the organization, method means that they don't actually have to come to court, which is, nice for them. First, NFIB's members appear to independently satisfy Article 3 standing requirements. Just like the individual plaintiffs that filed the lawsuit, NFIB's members, among whom are TTCS and Datacom, are reporting companies that fall subject to the CTA reporting rule. One additional example is Grazing Systems Supply, which is a reporting company, just like the individual plaintiffs discussed above. NFIB's members will incur compliance costs to comply with the CTA. Similarly, their grievance is against the CTA and the reporting rule, which are the government's regulations. Thus, NFIB's members individually satisfy Article 3 standing requirements. Second, the interests that NFIB seeks to protect through its participation in this litigation are certainly germane to NFIB's purpose. NFIB's purpose, in large part, is to advocate for small businesses. Accordingly, NFIB and its members oppose the CTA, and NFIB has advocated publicly for its repeal on behalf of its members that must comply with the Act and its implementing regulations. The precise interest that NFIB seeks to protect through its participation in this litigation is to ensure its members do not need to comply with the CTA and the reporting rule, which NFIB and its members contend is unconstitutional. That is pertinent to NFIB's purpose, especially as FinCEN notes the CTA will impact small businesses. Thus, the second prong of associational standing is satisfied here. Third and finally, the court asks whether the claim asserted or the relief requested would require NFIB's individual members to participate in the lawsuit. This concern is not constitutional but prudential. This final element concerns matters of administrative convenience and efficiency. In determining whether this prong of the standing analysis is satisfied, courts examine both the relief requested and the claim asserted. While an association's action for damages running solely to its members would be barred for want of the association standing to sue, where the association seeks declaratory or injunctive relief, the third prong is usually satisfied. So, just to be extra clear here, it's saying that, hey, if you're just stopping the enforcement, yes, the association's sufficient. But if the members have specific money to gain from a suit, well, they're saying, it'd be better if they were actually there to best advocate for themselves, to get money for themselves, right? So again, just stopping a harm, okay, the association can stand in and stop a harm for its wider membership. But if it were, not that and they were actually getting money, they'd want the people who, are there advocating for themselves getting money, not an intermediary to be advocating in court. So the court may safely continue the merits of this case. All right, plaintiffs' challenges to the Corporate Transparency Act and the reporting rule. This is where we're getting to the meat of the arguments. So this is what is it that makes this Corporate Transparency Act a problem and unconstitutional? The court now turns to the question of whether it should issue a preliminary injunction. The answer to that question turns on whether plaintiffs have carried their burden to prove, one, the CTA and reporting rules substantially threaten plaintiffs with irreparable harm. Two, substantial likelihood of success in the merits of any of their challenges. And three, that the threatened harm outweighs any damage the injunction might have on the government. And four, preliminary injunctive relief will not harm the public. The government disputes that plaintiffs have carried out their burden to satisfy each element. The court addresses each element seriatim. So, each piece by piece. So let's take a look at the substantial threat of irreparable harm. Plaintiffs must demonstrate they are likely to suffer irreparable harm in the absence of preliminary relief. Irreparable harm is harm for which there is no adequate remedy at law. In the Fifth Circuit, the non-recoverable costs of complying with a putatively invalid regulation typically constitute irreparable harm. That makes sense, as compliance costs may constitute irreparable injury where they cannot be recovered in the ordinary sense of litigation. Such is the case in regulatory challenges and suits against the United States like this one, because the federal government generally enjoys sovereign immunity for any monetary damages. Ooh, look at that right there. So that's a big deal, right? This is something that a lot of people don't think about or know. But, if you have compliance costs with the government and you're like, oh, but that was unconstitutional, federal government in many cases has sovereign immunity where you can't get money from them because you complied. So that's kind of interesting, to think about that. Oh, okay, you'd have an injury because if you complied, and they're like, oh, oops, our bad, it was unconstitutional. Oh, well, now you're out the money. So It's why injunctions matter. It's if you are wondering, why would you just do an injunction at all and not, go for the case? Well, that shows it right there. You don't want to have to comply and pay money, especially if there's a chance you might not get it back. Thus, as the Fifth Circuit has recognized time over, complying with a regulation later held invalid almost always produces the irreparable harm of non-recoverable compliance costs. To constitute irreparable harm, however, such compliance costs must be more than speculative. Instead, plaintiffs must have more than an unfounded fear of incurring such costs. Separately, when alleged deprivation of constitutional right is involved, most courts will hold that no further showing of irreparable injury is necessary. Here, plaintiffs allege the CTA and the reporting rule, if not enjoined, will irreparably harm them in two ways. First, plaintiffs contend simply that, absent an injunction, they'll be forced to comply with the CTA and the reporting rule. As a result, plaintiffs would have to expend resources and spend time and effort to make the required filings. In furtherance of their compliance efforts, plaintiffs aver that they would also incur legal expenses. Every individual plaintiff filed a declaration in which they swore that they would incur these costs should the CTA and the reporting rule remain in force. Similarly, NFIB filed a declaration in which it swore that if the CTA and reporting rule are not enjoined, its members would incur compliance costs and legal expenses associated with fulfilling its obligations under the CTA and reporting rule. The government stipulated that the plaintiffs would have testified to the same at the court's October 9th hearing should they have testified. So, of course, the government's like, well, yeah, you're right. We'd go after them. The second manner that the CTA and reporting rule allegedly threaten plaintiffs with irreparable harm is that the CTA and reporting rule violate their rights under the First, Fourth, Ninth, and 10th Amendments to the Constitution. To plaintiffs, the mere threat of revealing protected information on pain of criminal punishment constitutes irreparable harm. Now, this is where it gets interesting on the rights issues. The government sees it differently. Quite differently. According to it, neither of plaintiffs' bases for irreparable harm are sufficient. First, the government contends that plaintiffs cannot establish irreparable harm due to compliance costs. It argues that the evidence plaintiffs cite in support of the compliance costs they would incur is wholly conclusory, consisting of a single statement in the non-associational plaintiffs' declarations. It argues. Second, the government submits that any compliance costs plaintiffs would incur are de minimis. This almost, it sounds like the biggest gaslighting possible, right? Oh, you probably wouldn't, but you know what? If you did, it would be so small, it'd be de minimis. In support, the government notes that plaintiffs, by their own admissions, have already determined they are reporting companies subject to the CTA reporting rule. The beneficial ownership report form is free, and the information the plaintiffs would have to disclose is in the place of words readily available. The government argues. In essence, because the government believes that the reporting process is simple, any cost plaintiffs incur are de minimis, militating against a finding that plaintiffs have proved they will suffer irreparable harm. So the argument goes. But the Fifth Circuit rejected both arguments wholesale just last year, characterizing them as meritless. To demonstrate irreparable harm, plaintiffs need not to plead a specific dollar amount representing the total amount of compliance costs they might incur. Stringently insisting on a precise dollar figure reflects an exactitude that our law does not require. Thus, it is enough that each plaintiff swore in their declarations that they will incur compliance costs and legal costs should they have to comply with the CTA reporting rule. Further, the government's assertions that NFIB, the associational plaintiff in this matter, did not discuss compliance costs in its declaration is demonstrably false and does not change this conclusion. NFIB swore that its members would incur compliance costs should the CTA reporting rule remain in force. This, too, is sufficient. Really shows you how much the government sucks, doesn't it? They're just all over the place and making up nonsense and trying to gaslight people about this. Moreover, the court and the government need not accept plaintiff's sworn word for it. FinCEN itself concedes that reporting companies will incur compliance costs of the same sort that plaintiffs describe in their declarations as a result of the CTA and reporting rule. FinCEN estimates the total cost of filing BOI reports is approximately $22.7 billion in the first year and $5.76 billion in the years after. And that's no joke. This concession bolsters the plaintiff's belief that they will suffer irreparable harm. It is ironic that the government suggests that plaintiffs must plead their compliance costs with greater specificity. Indeed, the government itself only provides estimates in the four broad ranges of compliance costs. The government seeks to hold the plaintiffs to a standard the law does not require. That plaintiffs' declarations don't include a specific dollar figure in no way reduces their showing of irreparable harm. Wow. I mean, it really shows you how grubby the government is here with their arguments. It's really disgusting. The court also disagrees with the government's position that it would, in essence, be too easy for the plaintiffs to comply with the CTA and reporting rule for their obligations to constitute irreparable harm. In support of its position that any harm plaintiffs would incur is de minimis, the government directs the court to the Northern District of Texas case, Second Amendment Foundation, Inc. That case does nothing to suggest that the costs plaintiffs face here are, in fact, de minimis. There, the court noted that the record simply did not illustrate the nature of the plaintiff's compliance costs, let alone they were not more than de minimis. Having no evidence to suggest that the regulation issue there would actually force the plaintiffs to suffer compliance costs, the district court concluded that the plaintiff did not show irreparable harm. All right, so there's been no evidence whatsoever and a little bit. They are consistent with the Fifth Circuit precedent. The district court did not define the contours of de minimis. Here, the record contains sufficient evidence to show that compliance costs plaintiffs face exceed some de minimis value. The court declines the government's invitation to make a bright line value judgment as to what quantum of pecuniary injury constitutes more than de minimis compliance costs. So bright line rule just means a very specific, narrowly spelled out value judgment. So the court here is saying, we're not going to say, oh, you have to have more than $50 to be de minimis or something. So to be sure, the plaintiff's alleged compliance costs must be more than de minimis to rise to the level of irreparable harm, but be consistent with precedent to define a specific dollar figure. The key inquiry here is not so much the magnitude, but the irreparability that counts. In any event, deprivations of constitutional rights come a few dollars at a time. Setting a bright line rule thus makes little sense in this context. Plus, FinCEN acknowledges that companies will incur compliance costs like those that plaintiffs allege. The government doesn't dispute that plaintiffs cannot recover these costs, right? So even the government say, yeah, you ain't getting that compliance money back. That's right. We got sovereign immunity. Get out of here. It's crazy. The government, it's like a band of criminals and they can just get away with whatever and to say, oh, well, too bad, so sad. We're sovereign and you're not. It's really evil. Thus, the government's argument on this point is unavailing. Next, the government claims that compliance is not a heavy lift for the plaintiffs, but that is not the standard. To reiterate, complying with a regulation later held invalid almost always produces the irreparable harm of non-recoverable compliance costs. There is nothing in these facts or at law to suggest that the court should treat this as an abnormal case, nor not subject to this general rule. The compliance costs plaintiff alleges are unrecoverable and more than de minimis. The costs are far more than speculative, as FinCEN itself acknowledges, and the government wisely does not dispute. Thus, plaintiffs have met their burden to show that, absent injunctive relief, they will suffer irreparable harm. And it's funny because they say the government wisely does not dispute, because if the government disputed it, then it would throw their whole regulatory scheme out the window, because they'd be saying, wait. So all these typical companies and organizations, this doesn't apply to them. They don't have, it'd be them like basically countering the idea that it applies to them entirely. So it'd be like completely destructive to their case. So that's why they have to admit, oh yeah, it does apply to them. Despite having determined that plaintiffs have met their burden to show impending irreparable harm in the form of compliance costs, for the avoidance of doubt, the court will address plaintiffs' second theory of irreparable harm. Plaintiffs alternatively allege that they will suffer irreparable harm because the CTA reporting rule putatively violate their constitutional rights. To the government, however, an alleged constitutional violation alone will not suffice. The government notes the invocation of the First Amendment cannot substitute for the presence of an imminent non-speculative injury. Hence, the government argues it would be improper to hold that plaintiffs would suffer irreparable harm solely based on plaintiffs' allegation that their constitutional rights have been violated. In support, the government cites two opinions. First, it points the court to Castro v. City of Grand Prairie, an unpublished case. There, a pro se plaintiff, meaning someone suing without an attorney on their own, sought a temporary restraining order and brought claims under 42 U.S.C. 1983. And if you don't know what 42 U.S.C. 1983 is, that is one of the ways that you can sue government officials for violation of your rights under color of law. It's a very common means to that end. The plaintiff, a candidate for political office, alleged that the city of Garland violated his rights under the First Amendment and Equal Protection Clause when a county sheriff threatened to remove the plaintiff's campaign signs across the county. He further alleged the city violated his rights when a county official removed his campaign signs that were placed on private property. The district court denied emergency relief for two reasons. First, the plaintiff's TRO application consisted of one page of conclusory assertions, and his complaint was devoid of any allegations that would satisfy the requirements for liability under Section 1983, because that section has its own rules about what you have to meet. Second, and as a result of his conclusory allegations, plaintiff failed to prove that he faces substantial threat of irreparable harm. The government also relies on Sheffield v. Bush for the same proposition. There, two homeowners challenged an order issued by the Texas General Land Office that impacted the homeowner's property. The homeowners sought a preliminary injunction against the order's enforcement and a declaratory judgment that the order amounted to an unconstitutional taking that also violated both the Fourth Amendment and the Due Process Clause. The court denied the plaintiff's motion for preliminary injunction for what appear to be two principal reasons, at least as relevant here. First, the court was not yet convinced that plaintiffs had shown a constitutional violation. Second, the court found that an allegation of a constitutional violation taken alone was not sufficient to establish an irreparable injury. In reaching this conclusion, the court recognized that in Elrod v. Burns, the Supreme Court held that the loss of the First Amendment freedoms, even for minimal periods of time, unquestionably constitutes irreparable injury. The court noted the Fifth Circuit had yet to apply Elrod to the cases outside of the First Amendment context. But neither of these cases suggest that plaintiff has not met their burden here. Whereas the court in Castro determined that the plaintiff had not shown irreparable harm because his allegations were conclusory, that is not the case here. Rather, the record before the court contains sufficient facts to indicate the CTA and the reporting rule may violate the Constitution. The court does not detect a deficiency in plaintiff's pleadings. So this is why the court is already leaning toward saying there's a constitutional violation, a rights violation. The government's reliance on Sheffield is no more persuasive. First, the First Amendment is at issue in this case. Second, it appears that the Fifth Circuit has applied Elrod, or at a minimum, its undergirding principles, at least once outside of the context of the First Amendment. There is no reason it should not apply here. Any other conclusion would render the Fifth Circuit's well-established position that when an alleged deprivation of constitutional right is involved, most courts hold that no further showing of irreparable injury is necessary, a nullity. Thus, upon showing that an alleged fundamental right is either threatened or in fact being impaired, a movement is substantially threatened with irreparable injury that cannot be undone by monetary relief. So it's very important here to note that this is something different. When it comes to these fundamental rights, when it comes to constitutional rights, that the right is being infringed is on its own sufficient. It doesn't have to tie to anything with financial issues. So it's a big difference between the regulatory aspect. Here, plaintiffs claim that the CTA violates three fundamental rights. First, the right to be free from laws that Congress does not have authority to enact. That's your 9th and 10th Amendments there. Second, plaintiffs allege the CTA and reporting rule violate their rights in the First Amendment. And third, plaintiffs contend the CTA and reporting rule violates their rights in the Fourth Amendment. So First Amendment might be compelled speech, right? Having to submit information. Fourth Amendment, invasion of privacy aspect, that penumbra because of, the papers and effects. They're forcing people to hand over papers and effects as an invasion of privacy. The invocation of these rights is not a substitute for the presence of an imminent or non-speculative injury, as the government points out. But plaintiffs must comply with the CTA and reporting rule by January 1st, 2025. The government does not protest that impending deadline. And if plaintiffs must comply with an unconstitutional law, the bell has been rung. Absent injunctive relief, come January 2nd, 2025, plaintiffs would have disclosed the information they seek to keep private under the First and Fourth Amendments and surrendered to a law that they contend exceeds Congress's powers. That damage cannot be undone by monetary relief. That harm is irreparable, right? So the violation of your fundamental rights, that is irreparable harm right there. Because plaintiffs have met their burden to show that they will suffer unrecoverable compliance costs absent emergency relief, they have met their burden to show that the CTA and reporting rule threaten substantial, imminent, non-speculative, and irreparable harm. Independent of the specter of compliance costs on the horizon, plaintiffs have met their burden to show that the threat of irreparable harm because the CTA and reporting rule substantially threaten their constitutional rights. Now we get to likelihood of success on the merits. Very important. The court turns next to the merits of the case and asks whether plaintiffs have carried their burden to show a substantial likelihood of success in the merits. Making this determination, the court must carefully measure the CTA and the reporting rule against our written constitution in an effort to resolve this matter of first impression in the Fifth Circuit. This inquiry requires extensive analysis and begins with a discussion of the type of challenges the plaintiffs bring against the CTA and the reporting rule. Plaintiffs mount two types of attacks against the CTA. Plaintiffs contend the CTA and the reporting rule are unconstitutional, both facially
and as applied. In other words, as it's written and as they're going to use it. A facial challenge means a claim that the law is invalid in toto and therefore incapable of any valid application. All right, as it's written is a violation. Challenges of these sort against legislative acts are the most difficult challenge to mount successfully, since the challenger must establish that no set of circumstances exists under which the act would be valid. That is a tough standard to meet. As applied challenges are narrower and less burdensome. An as applied attack requires the court to decide whether a statute is administered unconstitutionally against a particular plaintiff. Right, so it's a bit more narrow. Hey, you're using the statute in a way that is unconstitutional and has to be changed. In cases such as this one, where a litigant brings both as applied and facial challenges, courts generally decide the as applied challenge first because it is the narrower consideration. However, this general rule might change in the context of enumerated powers challenges. By their very nature, almost all constitutional challenges to specific exercises of enumerated powers, particularly the Commerce Clause, are facial. Right, so they're saying right here, this as applied here, if we're looking at this and they're trying to draw on the Commerce Clause that the federal government can just regulate whatever, it's interstate commerce, then this law is going to potentially be struck down in its entirety, not just as it's applied, but it goes too far beyond the Constitution. When a federal statute challenge is going beyond Congress's enumerated powers under Supreme Court precedent, the court first asks whether the statute is constitutional on its face. If the statute survives that challenge, the court may proceed to analyze whether the statute can be validly applied to litigants. Here, the first issue before the court is whether Congress has the power to enact the CTA. Only if Congress has the authority to pass the CTA does it make sense for the court to take up plaintiffs' as applied challenge and their attacks on the CTA under the First and Fourth Amendments. Thus, in keeping with that logic, the court takes up the facial attacks first, starting with plaintiffs' enumerated powers challenge under the 10th Amendment. So this is where it's going to get really spicy, because they're bringing in constitutional issues that don't often get brought up and are often not successfully done. So this will be interesting. Number one, whether Congress exceeds its authority in passing the CTA. This issue invites a return to first principles. Since our nascency, it has been universally admitted that our government is one of enumerated powers. Congress's powers are expressed and defined in our Constitution. not going to cite that. Thus, Congress may only exercise those powers the Constitution expressly vests with it. The states and the people retain the remainder. And that's, of course, talk about the 10th Amendment there, because that is important to know. The enumeration of these powers is also a limitation of powers, because enumeration presupposes something not enumerated. The Constitution's express conferral of some powers makes it clear that it does not grant others. Vast as Congress's powers may be, it still must show that a constitutional grant of power authorizes its actions. Thus, the federal government is not equipped with a federal police power to regulate all aspects of public life. That power belongs to the states alone. This principle of federalism, rudimentary in our system, protects the liberty of the individual from arbitrary power. So now we're getting to federalism, federal power versus states power. It's going to get really interesting. Obvious as these notions are, more than 2 centuries ago, Chief Justice Marshall observed that the question respecting the extent of the powers actually granted is perpetually arising and will probably continue to arise so long as our system shall exist. He was right. Some 204 years later, plaintiffs' challenge to the CTA poses yet another iteration of this question. As our system has evolved and the powers of that the government wields have ebbed and flowed, parties have turned to the judiciary to safeguard the promises of the 10th Amendment. Plaintiffs call upon the court to do so once more. But a plea to the court should not be misconstrued as an invitation for judicial activism. See, and this is where you're seeing the judge having that balancing act. They're trying to also make sure, okay, well, we're not making laws from the bench, right? We're restricting things. So that's going to be really interesting. Assessing the constitutionality of a legislative act requires the court to bear in mind its limited role in policing the boundaries of the government's power. The court does not wade into the treacherous waters of policymaking. Neither will the court opine as to whether legislative action constitutes good governance or sound judgment. For these matters are entrusted to the nation's elected leaders. So, important note, if you're a strict constructionist or an originalist type of judge, they're not deciding whether they think it's a good idea or bad idea on its own, simply whether it is enumerated or not enumerated powers, delegated, not delegated powers. Instead, the court need only assess whether Congress has the power under the Constitution to enact the challenge provisions. Modest as this function is, judicial deference to a co-equal branch does not render the judicial function a nullity, nor does it give Congress unbridled discretion to act whatever legislation it chooses. History is marked with occasions where Congress's good faith exercise of power has strayed too far, and where courts, acting in their unique and exclusive province, have restored the balance by striking down a law as beyond Congress's authority. Though our Constitution excludes the court from governance and policymaking, the court embarks alone in matters of legality and constitutionalism. It is emphatically the province and duty of the judicial department to say what the law is, and sometimes what the law cannot be. And if Congress lacks the power to enact a given law, that law is no law at all. Plaintiffs contend the CTA simply cannot be a valid exercise of Congress's enumerated powers. The government disagrees. It suggests that two provisions of the Constitution authorize the CTA, the Commerce Clause and the Necessary and Proper Clause. And it's going to get real tough because those clauses have been used to justify all kinds of government actions, but as of late, they've started to get reined in. If the CTA is authorized by either, then the court must reject plaintiff's facial attack under the 10th Amendment as a failure to show that their challenge is likely to succeed in the merits. The court measures the CTA against each proffered clause in turn. So first, the Commerce Clause, the most controversial and often used justification for the federal government trying to do anything and everything willy-nilly, sadly, especially since U.S. Reich in 2005. So the Constitution vests Congress with the exclusive power to regulate commerce with foreign nations and among the several states. Chief Justice Marshall, writing for the Supreme Court in 1824, first defined commerce, stating, "Commerce undoubtedly is traffic, but it's something more. It is intercourse. It describes the commercial intercourse between nations and parts of nations in all its branches and is regulated by prescribing rules for carrying on that intercourse." The Commerce Clause is the power to regulate, that is, to prescribe the rule by which commerce is governed. While the breadth of Congress's commerce power has waxed and waned over the years, ultimately resulting in Congress having broad authority to regulate commerce, that power is not limitless. Sounding good. The Supreme Court has cautioned that the Commerce Clause must be considered in light of our dual system and may not be extended so as to create a completely centralized government. Right. Against this backdrop, the Supreme Court has identified three broad categories of activity that Congress may regulate under its commerce power. They are: 1, the channels of interstate commerce; 2, the instrumentalities of interstate commerce and persons or things in interstate commerce; and 3, activities that substantially affect interstate commerce. And that number 3 is the one that's been really problematic because trying to rationalize that anything and everything can possibly affect interstate commerce to points of absurdity. So, and there's that Gonzalez v. Rice case there. The government incorrectly contends that each category independently authorizes the CTA. All right, bullet point A here, the CTA does not regulate channels of or instrumentalities in commerce. The court begins with the first two categories and handles them together. The government argues that the Commerce Clause authorizes the CTA because it regulates the channels of and entities in interstate commerce. In support of this theory, the government cites American Power and Light Co., the SEC, arguing that Congress, of course, has undoubted power under the Commerce Clause to impose relevant conditions and requirements on those who use the channels of interstate commerce, so that those channels will not be conduits for promoting or perpetuating economic evils. The government also relies upon North American Co. v. SEC for the same proposition. It notes that the Supreme Court has said, to the extent that corporate business is transacted through such channels affecting commerce in more states than one, Congress may act directly with respect to that business to protect what it conceives to be the national welfare. And it may prescribe appropriate regulations and determine the conditions under which the business may be pursued. Because some reporting companies use the channels of interstate commerce, including telecommunications and electronic banking systems, the government may regulate all reporting companies, so the argument goes. Further, the government claims that Congress's commerce power permits it to regulate directly those entities who seek to misuse those channels to commit economic crimes. These arguments misinterpret the scope of Congress's power to regulate channels of and instrumentalities in interstate commerce. The Supreme Court and Fifth Circuit alike define the channels of interstate commerce as the interstate transportation routes through which persons and goods move. This category extends beyond the regulation of highways, railroads, air routes, navigable rivers, fiber optic cables, and the like. The Supreme Court affirmed that Congress may regulate in this category to prohibit discrimination in public accommodations, and noted that Congress has used the Commerce Clause to prevent illicit goods from traveling through the channels of commerce. In contrast, the term instrumentalities in interstate commerce is understood to refer to the planes, trains, and automobiles of commerce, along with the persons associated with them. And that, just noting, the instrumentalities of commerce are generally held to be the people and things themselves moving in commerce and the people who make commerce possible. So, persons or things in interstate commerce. And then they define instrumentalities as persons or things moving in commerce, including regulation, protection pertaining to instrumentalities of things as they move in interstate commerce. While the government begins its argument with an assumption that the CTA regulates companies that use channels or instrumentalities in interstate commerce, the court starts the inquiry, as always, with the statute's text. The CTA regulates reporting companies, which the Act defines as an entity or created by the filing of a document with the Secretary of State or a similar office under the law of a state or Indian tribe, or formed under the law of a foreign country and registered to do business in the United States by the filing of a document with the Secretary of State or similar office under the laws of a state or Indian tribe. As a result of having so registered, a CTA requires those companies to divulge their beneficial ownership information to FinCEN on pain of civil and criminal punishment. The District Court for the Northern District of Alabama, faced with this definition, held that the CTA does not regulate by its text a channel or instrumentality of commerce. So note here, they're agreeing with another court that had an injunction for a limited class of persons that if you are trying just to regulate and say, hey, anyone who files a corporation, you're under this. Well, that's not in itself the instrumentality of interstate commerce. It's not, a vehicle or people moving in interstate commerce. And it's not even saying that the business itself is engaged in interstate commerce, because as there was noted before, there were businesses that did business wholly within the state. They didn't do business outside the state. So that's a big problem. That's a big challenge. There's nothing interstate by default in the definition. The court agrees with its sister court. The word commerce or references to any channel of instrumentality of commerce are nowhere to be found in the CTA. And when examining the CTA's language, the court must presume that Congress says in a statute what it means and means what it says, what it means in a statute what it says. Companies generally do not fit into either category. They are not a channel or instrumentality of commerce. And this is just a case saying collecting cases indicating that channels and instrumentalities of commerce are the pathways of commerce and the items moving, right? So the corporate fiction is not a pathway. It's not the good moving in commerce. If they were, then Congress could regulate any company in any way all the time. There's no limiting principle in that, and precedent does not support acceptance of such a capacious construction of the words channel and instrumentality. Though the CTA does not directly regulate channels or instrumentalities of commerce, the government contends that Supreme Court precedent extends Congress's ability to regulate in this realm to companies that use channels and instrumentalities of commerce. Indeed, it is well settled that Congress can invoke its commerce power to regulate those who use the channels of interstate commerce in order that those channels would not become the means of promoting or spreading evil, whether of a physical, moral, or economic nature. But this granted power, too, does not write Congress a blank regulatory check. In American Power and Light Co., two public utility holding companies challenged a public utility holding act as outside Congress's commerce power. The Public Utility Holding Act authorized the SEC to require registered holding companies to ensure that the company's corporate structure did not unduly or unnecessarily complicate the structure or unfairly or inequitably distribute voting power among security holders. The Supreme Court held the act largely because Congress aimed at solely to public utility holding company systems that used channels of interstate commerce. But Congress did not include such an express aim in the CTA. It does not only regulate those companies that use channels or instrumentalities. Instead, it assumes that every company does use channels and instrumentalities of interstate commerce without a jurisdictional hook of any kind that would limit the CTA's reach to only those companies who do not use those channels or instrumentalities. As the District Court NBSU versus Yellen observed, that theory exceeds the boundaries of the Commerce Clause. Accordingly, the government must seek to justify the CTA through a different avenue. So right off the bat, Commerce Clause, not going to work. It's not specifically applying to instrumentalities of commerce or pathways. They're just saying, hey, any corporate fiction, we get to regulate you just because no predicates, no qualifiers. So the court's not having it, just like the Alabama court didn't either. And I agree. The CTA does not regulate an activity, it creates one. Very true. Because the CTA does not regulate the channels or instrumentalities of commerce, it may only be sustained under the third category of Congress's commerce power. That is, it must regulate an activity which in the aggregate substantially impacts interstate commerce. And this is going back to that Reich case where, and again, this is a terrible case, horrible case, one of the worst Scalia opinions, but he said that, growing cannabis at your own home affects interstate commerce in the criminal sense because, that's a criminal thing to have, your own cannabis. And I mean, it just really needs to be repealed. That was a terrible case. It makes absolutely no sense that someone growing plants in their own home in and of itself affects interstate commerce. That's crazy. All right. This is the government's last hope to justify the CTA as a bare exercise of Congress's power under the Commerce Clause. But before launching into this inquiry under Congress's third category of commerce power, there's a threshold issue which has at times foreclosed Congress's ability to legislate under the umbrella of this third category. In NFIB versus Sabelis, the Supreme Court drew attention to this initial hurdle. Simply put, legislation of the Commerce Clause must regulate an existing activity, not compel activity. The power to regulate commerce presupposes the existence of commercial activity to be regulated. If the power to regulate something included the power to create it, many provisions of the Constitution would be superfluous, right? Because it's just, we can force you to act now and then regulate it. Concomitant with this rule is nuance. At issue in Sabelis was the Affordable Care Act's individual mandate provision, which forced individuals to purchase health insurance to provide a minimum baseline of coverage. In assessing whether Congress, under the Commerce Clause, had the power to enforce the individual mandate, the Supreme Court noted that all of its precedent had one thing in common. They uniformly described the power as reaching activity. Where economic activity substantially affects interstate commerce, legislation regulating the activity will be sustained. Another case is where the class of activities is regulated, and that class is when the reach of federal power, the courts have no power to excise as trivial individual instances of the class. Another landmark case, the Wickard v. Filburn case, even if appellee's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce. Again, another terrible case that must be overturned. Crazy. All right. And that Jones versus Laughlin Steele, although activities may be intrastate in character when separately considered, if they have such a close and substantial relation to interstate commerce that their control is essential or appropriate to protect that commerce from burdens or obstructions, Congress cannot be denied the power to exercise that control. So thus, for Congress to properly exercise its power to regulate commerce, it cannot force one to engage in an activity for the sole purpose of having something to regulate. I mean, really, because there's nothing left after that, right? And the government can force you to take an activity just to regulate it. There's nothing left. You could just be a total slave to the federal government. All right. The Supreme Court rejected the government's theory that the Commerce Clause empowered Congress to enact the individual mandate precisely because it did not regulate a pre-existing activity. It created one of its own. Rather than regulating a commercial activity, the Supreme Court reasoned the individual mandate compels individuals to become active in commerce by purchasing a product on the ground that their failure to do so affects interstate commerce. But this, the Constitution does not permit. Any other holding would effectively override the Commerce Clause's limitations by establishing that individuals may be regulated under the Commerce Clause whenever enough of them are not doing something the government would have them do. Like the individual mandate, this is where the government's proffered Commerce Clause justification of the CTA begins to unravel. Have a drink of water real quick. All right. Initially, plaintiffs, consistent with separate litigation against the CTA occurring across the nation, argue that the CTA regulates the act of registration under state law. But at the court's October 9th hearing, plaintiffs abandoned that characterization. Instead, plaintiffs suggest that the CTA does not regulate an activity at all, but rather that the CTA regulates on an ongoing basis reporting companies and beneficial owners. In its response, the government did not articulate what precisely the activity is that I think they wrote this. And in its response, the government did not articulate what precisely the activity is that Congress strives to regulate through the CTA. The government's response does, however, tacitly dispute plaintiff's initial position, arguing that the CTA does not purport to override or preempt any state law and corporation provisions. Still, this does not answer the narrow question. What is the activity the CTA regulates? Once more, the court's hearing provided clarity. There, the government stated that the conduct that the CTA regulates is the anonymous existence and operation of corporations. The government takes a substantially similar position in litigation involving enumerated powers challenges to the CTA in courts across the country. The government argues that the CTA does not purport to regulate corporate entity formation. Rather, the CTA governs the conduct of a covered entity as an ongoing concern. The court agrees with the government's framing of the issue, that the CTA changes, in a way, the process of registration under any state law is non sequitur. It adds nothing to nor detracts in any way from the registration process under state law. Instead, it uses the act of registration as a triggering event for the CTA's applicability. Thus, the court agrees that the CTA does not regulate the act of registration, consistent with the District Court for the Eastern District of Virginia. But that framing is fatal to the government's position. Womp womp. At first blush, the anonymous existence and operation of corporations might appear as an activity. After all, operation is an action. And they use Black's Law Dictionary to say that, defining operation as a state or condition of functioning or being in action. But the CTA, by its text, does not appear to regulate operation at all. It does not forbid a company from doing anything except insofar as it forbids a reporting company's failure to file an updated BOI report. Instead, by its text, it seems to only regulate an entity's existence simply because reporting companies are by their nature anonymous. And anonymous existence is not an activity at all. It is a state of being, defining existence as a state or a fact of having being and the manner of being that is common to every mode of being. And that's a real, right? Talking about some legalese fights over words, right? Acting anonymous is not an action. It's just a state of being or being the state of being anonymous, right? It is the natural idle state that any entity formed by registering with the Secretary of State necessarily takes on by virtue of its registration. It is akin to a person being alive in their natural state, indistinguishable from an individual choosing to refrain from purchasing health insurance. That is not an activity, right? It's not a positive activity. It's just you are. And the regulation of this natural state of being seems to be exactly what the Supreme Court rejected in Sibelius. So the question arises, why would Congress seek to regulate the anonymous state of being that reporting companies assume as a consequence of the registration? The AMLA answers the question plainly. Money launderers and others involved in commercial activity intentionally conduct transactions through corporate structures in order to evade detection and may layer such structures, much like Russian nesting Matryoshka dolls, across various secretive jurisdictions, such that each time an investigator obtains ownership records for a domestic or foreign entity, the newly identified entity is in another corporate entity, necessitating a repeat of the same process. So basically, hey, we don't want to have people money laundering and hiding who owns what. And absent something akin to the CTA, the government claims that it faces great difficulty in enforcing its financial crimes laws. In other words, the CTA is a law enforcement tool, not an instrument calibrated to protect commerce and exercise of police power, rather than a regulation of activity which might impair commerce among the several states. This, the Commerce Clause will not tolerate. In rejecting a Commerce Clause justification for the individual mandate in Sibelius, the Supreme Court held that it compelled individuals to become active in commerce by purchasing a product on the ground their failure to do so affects interstate commerce. Here, analogous language explains the CTA. The CTA compels reporting companies to file a beneficial ownership report with the federal government, an act that no state's registration laws require, on the ground that their failure to do so affects interstate commerce. The government argues just this, though in fewer words, in its response. But the court need not reach the traditional aggregate effects inquiry because the CTA does not regulate an activity within the meaning of the Commerce Clause. Indeed, construing the Commerce Clause to permit Congress to regulate individuals precisely because they are doing nothing would open a new and potentially vast domain to congressional authority. In the same vein, construing the Commerce Clause to permit Congress to regulate companies precisely because the government does not know who substantially benefits from their ownership would similarly open a new and potentially vast domain to congressional authority. Allowing Congress to justify federal regulation by pointing to the effect of the government's lack of information about beneficial owners on commerce would bring countless decisions a company could potentially make within the scope of federal regulation, and under the government's theory, empower Congress to make those decisions for it. That cannot be so. To be sure, as the government points out, various economic crimes are made easier to commit and harder to discover through the formation of corporate entities that may conduct economic transactions in their own names without disclosure of beneficial ownership information. The notion that one may use a company to veil their illicit financial crimes is unassailable. But the Commerce Clause does not justify regulating all companies based on nothing more than the fear that a reporting company might shelter a financial criminal, right? This is pre-crime here. It's literally saying, hey, you're all going to be treated as if you're criminals off the bat and have to comply and act and take action. The proposition that Congress may dictate the conduct of an individual solely today's because of prophesied future activity finds little support in Supreme Court precedent. The Commerce Clause does not furnish Congress with police power or a general license to regulate an individual from cradle to grave simply because he will predictably engage in particular transactions. It stands to reason that the Commerce Clause does not bless Congress with carte blanche to regulate all companies in perpetuity simply because they might engage in commerce or one might use them to conceal criminal activity. Any decision affirming the propriety of the government's tenuous use of the Commerce Clause here would require the court to pile inference upon inference in a manner that would bid fair to convert congressional authority under the Commerce Clause to a general police power of the sort retained by the state. The court will not interpret the Commerce Clause in such a lax manner. Perhaps this is why Congress has never before sought to regulate financial crimes in this way. But that alone raises judicial eyebrows at the constitutionality of the CTA. Sometimes the most telling indication of a severe constitutional problem is the lack of historical precedent for Congress's action. When faced with legislative acts that deviate from the historical status quo, courts at the very least must pause to consider the implications of the government's arguments. In taking that pause, it appears that sanctioning the CTA under the Commerce Clause would be to rubber stamp a new form of federal power. But that power threatens the very fabric of our system with federalism. Because the CTA does not regulate a pre-existing activity, but instead compels a new one, the CTA exceeds Congress's commerce power. That should be the end of the matter. But for the avoidance of doubt, assuming arguendo that the anonymous existence and operation of corporations constitutes an activity for purposes of the Commerce Clause, the CTA still lays beyond Congress's commerce power. So this is awesome that the court is saying, hey, even if we assume this is true, which we don't agree with, we're going to go even further to say, well, this is unconstitutional. So really good on them. Even if anonymous corporate existence and operation is activity regulable under the Commerce Clause, the CTA fails to pass muster. Congress may not invoke the substantial effects doctrine to regulate future activities or no activity at all. Thus, the court need not perform further analysis under the third category of commerce power, activities that in aggregate substantially impact interstate commerce, to hold that at this stage, plaintiffs have satisfied their burden to show the CTA falls outside the scope of the Commerce Clause. But to give the government every benefit of the doubt, as the court must, the court will no less analyze whether Congress may regulate anonymous corporate existence and operation under this third category. I love how they say that here. They say, we're just giving the benefit of of doubt to the government here to go ahead and strike them down extra. Instead of saying, well, we're just going to stay because we've reached the point in the merits and we don't need to go. We reached the point on the part so far. We don't need to go further, but we're going to go further just to give the government the benefit of the doubt, but we're going to strike them down again anyway. I really love that. That's great. In its attempt to justify the CTA, the government principally relies on Gonzalez v. Reich, arguing that Congress may regulate activities that substantially affect interstate commerce. The government continues to contend that when Congress legislates pursuant to its commerce power under this third category, it may regulate purely local activities that have substantial effect on interstate commerce. The government suggests that the court, in analyzing the legislative act's propriety in this category, need only determine whether a rational basis exists for concluding that the regulated activity taken in the aggregate substantially impacts interstate commerce. And rational basis is the lowest review standard, and judicial standard on government activity. It means if they have any rational nexus to, reason as to why this, could work or be affected, then Congress can do it. So pretty bad to have, obviously, for the Commerce Clause. I think they they really need, some compelling interest, strict scrutiny kind of scrutiny on the government there. But a close reading of Reich and its predecessors revealed that while the government articulates the right standard, the CTA still fails constitutional scrutiny. In United States v. Lopez, the Supreme Court aptly summarized the sum of Commerce Clause jurisprudence, which bears repeating, as none of the court's Commerce Clause cases can be viewed in isolation. In Jones and Laughlin Steel Corp., the Supreme Court addressed a challenge to the National Labor Relations Act, which regulated interstate employment practices. The court held that Congress has the power to regulate those interstate activities that have such a close and substantial relation to interstate commerce that their control is essential and appropriate to protect that commerce from burdens and obstructions. Thereafter, the court upheld the Fair Labor Standards Act in the face of a challenge under the Commerce Clause and stated, The power of Congress over interstate commerce is not confined to the regulation of commerce among the states. It extends to those activities intrastate, meaning within the state, which so affect interstate commerce or the exercise of the power of Congress over it as to make regulation of appropriate means to the attainment of a legitimate end, the exercise of the granted power of Congress to regulate interstate commerce. Again, horrible ruling. This idea that, if something that happens wholly within a state could potentially affect commerce outside the state, well, then we have a right to regulate it. Really sick. So Congress's power under the Commerce Clause extends to those intrastate activities which in a substantial way interfere with or obstruct the exercise of granted power. Subsequently, in the landmark case of Wickard v. Filburn, the Supreme Court interpreted the Commerce Clause to permit Congress to regulate the production and consumption of homegrown wheat, right? Homegrown wheat. Oh, yeah, we get to control your homegrown wheat. An interstate non-economic endeavor. The court observed, consistent with its holdings in Darby, Jones, and Wrightwood, even if the wheat farmer's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce, and this irrespective of whether such effect is what might at some time earlier time been defined as direct or indirect. Isn't that crazy? It's not commerce. You're just growing wheat on your own farm for yourself. But you know what? It could affect things down the road. So we get to regulate you. Just nuts. Really insane court in that court. The Supreme Court stressed that even though a single wheat farmer growing wheat for himself may have a trivial impact on the market for wheat, that reality alone was not enough to remove him from the scope of federal regulation, where his contribution taken together with that of many others similarly situated is far from trivial, right? So it's like, lots of people grow wheat at their home. You're going to affect wheat on the interstate level. So nuts. I mean, it's really, really wicked. These cases, the Supreme Court declared, ushered in an era of Commerce Clause jurisprudence that greatly expanded the previously defined authority of Congress under that clause. At that time, the limits of the court relied on interpreting the contours of the Commerce Clause with a dual system of government and a well-founded constitutional rooted fear of creating. At that time, the limits the court relied on in interpreting the contours of the Commerce Clause were the dual system of government and a well-founded, constitutionally rooted fear of creating a completely centralized government. Enter Lopez. At issue in Lopez was the Gun-Free School Zones Act of 1990, through which Congress criminalized as a matter of federal law the knowing possession of a firearm in a school zone. Another really crazy case, literally saying that, the government can regulate a gun to school, even though that has nothing to do with commerce and has nothing to do with interstate channels. It's literally just a school in a state, and there happened to be a gun there. I mean, it's just crazy. The Supreme Court struck down the act as outside of Congress's power under the Commerce Clause. So fortunately, that I was speaking to the issue beforehand when they said that they had the power to control it. Later on, obviously that was struck down. It was crazy that on the way up, the government was trying to say, we have the power to control this just because there's a gun to school. And so holding, the court first observed that the statute did not contain a jurisdictional element which would ensure through a case-by-case inquiry that the firearm possession in question affected interstate commerce. The court also noted that because the statute was not part of a larger regulation of economic activity in which the regulatory scheme would be undercut unless interstate activity were regulated, it could not stand under Jones and Laughlin Steel Court's progeny. But the court in Lopez did not explicitly appear to require such a regulatory scheme in all inquiries under the aggregate effects theory of Congress's commerce power. Further, the Supreme Court determined that there exists no rational basis for Congress to conclude that possession of a firearm in a school zone substantially impacted interstate commerce. The government argued that such a rational basis existed for two principal reasons. First, the government submitted that possession of a firearm in a school zone may result in violent crime, and the costs of violent crime are spread throughout the population through insurance. So insane. I really can't believe they actually passed that and argued that. Second, it argued that the presence of guns in schools possessed a substantial threat to the educational process by threatening the learning environment. Consequently, the government argued the possession of firearms in school zones would result in less productive citizenry that would impact the national economy. Can you believe that? You might disturb kids in school. Therefore, we get to control everything and anything as relates to guns and school zones and all sort of stuff because you might affect how people learn and then become productive. I mean, literally on that basis, they could do anything if this wasn't struck down. They could literally do anything. The Supreme Court rejected these arguments as devoid of any limiting principle that would bulwark congressional attempts to legislate in the realm of criminal law and education, arenas where states maintain sovereign status and historically legislate in such matters. The Supreme Court crystallized this framework further in United States versus Morrison, in which the court considered the constitutionality of a provision of the Violence Against Women Act, which provided a similar remedy for victims of gender-motivated violence. The court struck down the provision as outside Congress's commerce power, determining that the statute regulated a non-economic activity, gender-motivated violence. Obviously, that's not economic violence, is not people trading voluntarily, without a jurisdictional hook that would tie gender-motivated violence to interstate commerce. Additionally, the potential impact that gender-motivated violence might have on interstate commerce was far too attenuated to pass constitutional muster under an aggregate effects analysis. Once more, upholding the statute would have invited Congress to invade the province of the states to exercise their police power as they see fit. The court did not analyze whether the statute's absence would undercut a regulatory scheme. In Gonzalez v. Reich, the Supreme Court returned to the framework it espoused in Lopez and Morrison, further clarifying it. Reich considered a challenge to the Controlled Substances Act to the extent it prevented plaintiffs from possessing, obtaining, or manufacturing cannabis for their personal medicinal use, right? Which is crazy. You're going to say that personal cannabis consumption is an effect on interstate commerce? Okay. As was legal under California law. Specifically, the plaintiffs argued that the CSA's categorical prohibition of the manufacture and possession of marijuana as applies to the interstate manufacture and possession of marijuana for medical purposes pursuant to California law exceeds Congress's authority under the Commerce Clause. The court upheld the CSA, determining that the Commerce Clause permitted Congress to reach local interstate production and consumption of marijuana because it is a fungible commodity for which there is an established, albeit illegal, interstate market. Thus, Congress had a rational basis for concluding that leaving home-consumed marijuana outside of federal control would affect price and market conditions. Further, it concluded that Congress's attempt to regulate the national illicit market for marijuana would have been hampered, if not fully undercut, if the Commerce Clause did not reach intrastate possession and consumption of marijuana. Given this precedent, two principal rules emerge. One relating to when Congress can regulate economic activity, the other relating to when Congress may regulate non-economic activity. First, Congress may regulate intrastate activity if the statute facially regulates an economic activity and the court determines that a rational basis exists for Congress to conclude that activity, aggregated with all its iterations, substantially affects interstate commerce. Second, while thus far in our nation's history, the Supreme Court has upheld regulation of interstate activity only where that activity is economic in nature, Congress may still regulate non-economic activity. Congress may do so if the court concludes there is a rational basis for Congress to determine that the regulation activity substantially impacts interstate commerce. The regulation serves a comprehensive regulatory regime, and regulation of non-economic activity is necessary to preserve that broader regulatory regime. In this non-economic category of regulation, the court also looks to whether the statute contains a jurisdictional hook, and whether Congress provided any findings regarding the impact the activity might have on commerce. In both inquiries, courts must consider the Commerce Clause through the lens of our dual system of government and can extend its reach to embrace activities that would effectually obliterate the distinction between what is national and what is local and create a completely centralized government. Against this backdrop, the first question is whether activity of anonymous corporate existence and operation constitutes an economic activity. Unlike possession of a firearm in a school zone in Lopez's case, or gender-motivated violence in Morrison, the anonymous existence and operation of corporations appears to at least have something to do with commerce, but not to the same extent as Wickard and Reich, both of which involve fungible commodities and actual markets for that good. Nonetheless, it is rational for Congress to believe that registered entities in their natural state of anonymous existence and whatever operations they may carry out would substantially impact interstate commerce. But when considered in light of our dual system of government, Congress's commerce power cannot reach as far. So it's kind of wild that they're sitting here and saying, we're still upholding, Reich, but we're going to differentiate. So looks like they're turning toward limiting the Commerce Clause further, hopefully. If the court were to sanction such an extension of legislative power today, then there is no telling how Congress would control companies tomorrow. The fact that a company is a company does not knight Congress with some supreme power to regulate them in all aspects, especially through the CTA, which does not facially regulate commerce. This is especially true when such regulations are generally entrusted to states. No principle of corporation law in practice is more firmly established than a state's authority to regulate domestic corporations. Even when measured against Wickard, the most far-reaching example of Commerce Clause authority over interstate activity, the CTA fails. There is no fungible good at issue in the CTA. And unlike Wickard, The CTA does not aim to regulate some issue of supply and demand. The CTA regulates reporting companies simply because they are registered entities and compels the disclosure of information for a law enforcement purpose. No such regulation has been sustained under the Commerce Clause. The court sees no reason to expand centuries of precedent such that this case should yield a different result. Upholding the CTA require the court to rubber stamp what appears to be a substantial expansion of commerce power. This the court will not do. So as we can hear, the court has set some type of line here finally that, hey, maybe they could do intra-state, that is within state, commerce regulation if it's actually a fungible good and it deals with actual commerce, but just making a regulation against companies just because there's no actual good here, there's no service being traded or anything like that, you can't do it. Again, it's narrow, it's unsatisfying, for me personally, for how much the government needs to be cut back on this, but at least it's a start. The necessary and proper clause. Having established that the Commerce Clause does not justify the CTA, the court turns to the final arrow in the government's quiver, the necessary and proper clause. Its last best hope. If the necessary and proper clause does not authorize the CTA, then plaintiffs have shown a substantial likelihood of success in the merits on their enumerated powers challenge, warranting issuance of injunctive relief. Though our Constitution is written, and though our government is of enumerated powers, a government entrusted with such powers must also be entrusted with ample means for their execution. The framers knew this. As a result, the necessary and proper clause appears written in our Constitution, vesting Congress with the power to make all laws which shall be necessary and proper for carrying into execution Congress's enumerated powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. This power gives the legislative branch the authority to enact provisions incidental to enumerated power and conducive to its beneficial exercise. While the Supreme Court has defined the contours of the necessary and proper clause such that Congress may legislate on that vast, massive incidental powers, which must be involved in the Constitution, it does not license the exercise of any great substantive and independent powers beyond those specifically enumerated. Indeed, courts are responsible to declare unconstitutional those laws that undermine the structure of government established by the Constitution, as any such law does not constitute proper means for carrying into execution Congress's enumerated powers. To be effective, Congress must invoke the necessary and proper clause in tandem with enumerated power. Thus, in determining whether the necessary and proper clause grants Congress the legislative authority to enact a particular federal statute, the courts look to see whether the statute constitutes a means that is rationally related to the implementation of a constitutionally enumerated power. This means ends rationality is not a high bar. As Chief Justice Marshall declared in an off-quoted passage, let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to the end, which are not prohibited, but consist of the letter and spirit of the Constitution, are constitutional. Thus, the court has upheld statutes that are convenient, useful, or conducive to enumerated powers' beneficial exercise. But this standard is a bar, no less. Deference given to Congress once more cannot become an abandonment of the judicial responsibility to strike down ultra-virus congressional actions as mere acts of usurpation, which deserve to be treated as such. Within this framework, the government urges the court to take one of three avenues to arrive at the conclusion that the CTA is within the reach of Congress's powers. Behind door number one, necessary and proper clause in service of Congress's power to regulate commerce. Behind door number two, the necessary and proper clause in conjunction with Congress's power to regulate foreign affairs and further its national security interests. And behind door number three, or the third door, the necessary and proper clause in tandem with Congress's authority to lay and collect taxes, which that one is probably the scariest one, the worst one, because tax power has been given the broadest one. That's how the Affordable Care Act got through, was basically as a tax. So the scariest way they can do this is if they try to somehow associate the information with tax collection. Then it would possibly be very hard to take down, and we'd have to actually have a court that wants to really restrict the government and uphold maybe the 9th and 10th Amendments on new levels. So, that the third one's probably the scariest. The court opens each door in turn but shuts them all. The CTA finds no constitutional solace behind any door. Well, that's good. At least this court is trying to shut them all before they get opened later, potentially. The Commerce Clause and Necessary and Proper Clause. The court begins with Congress's power under the Commerce Clause and can dispose of it easily. As discussed, the Constitution grants Congress to regulate commerce. That regulatory power presumes the existence of a prerequisite activity. Just as the government's justification of the CTA as a raw exercise of commerce power would result in a severe expansion of Congress's power, The government's logic under the necessary and proper clause would justify a mandatory disclosure requirement to solve almost any problem. Requiring companies to disclose otherwise private information to the government simply because those companies exist in their natural state does not derive from Congress's raw commerce power. It is in no way an authority that is narrow in scope or incidental to the exercise of the commerce power. The court declines to authorize it as a necessary and proper use of Congress's commerce power precisely because to do so would be ignore the crux of the necessary and proper clause, which is not an exercise of any great substantive and independent power. The government suggests that Congress's power under the necessary and proper clause is even greater because the CTA covers foreign commerce. That argument is not persuasive. While the Constitution grants Congress the power to regulate commerce with foreign nations, that power is still regulatory in nature as a matter of the Constitution's plain text. Thus, though the founders intended the scope of the foreign commerce power to be greater than the interstate commerce power, that the CTA impacts foreign reporting companies as well as domestic ones there's nothing to mollify the grave constitutional concern that the CTA does not regulate activity at all. So again, it doesn't matter if it's also foreign companies. Well, you're not regulating activity at all, so it doesn't matter. Thus, the CTA cannot be upheld as a necessary and proper component of Congress's commerce power. Foreign affairs power and the necessary and proper clause. Next, the court assesses whether the CTA falls within the scope of Congress's power to regulate foreign affairs as modified by the necessary and proper clause. The government proclaims that Congress has the authority to pass the CTA because it has broad power under the necessary and proper clause to enact legislation for the regulation of foreign affairs and pertain to national security. Directing the court to a slew of immigration-related cases, the government asserts that the CTA is valid under the necessary and proper clause because Congress may legislate to protect the nation's national security interests and in furtherance of the president's power to execute the law. In further support, the government leans on Congress's findings enumerated in the NDAA, which discusses the CTA's impact on foreign actors. As the government notes, two of Congress's findings are salient to this inquiry. First, malign actors seek to conceal their ownership of corporations, limited liability companies, or other similar entities in the United States to facilitate illicit activity, harming the national security interests of the United States and the allies of the United States. Second, the government calls attention to Congress's determination that federal legislation providing for the collection of beneficial ownership information for corporations, limited liability companies, or other similar entities formed under the laws of the United States is needed to protect vital United States national security interests, better enable critical national security, intelligence, and law enforcement efforts to counter money laundering, the financing of terrorism, and other illicit activity, and bring the United States into compliance with international anti-money laundering and countering the financing of terrorism standards. According to the government, the sum of these findings, Congress's foreign affairs powers, and necessary and proper clause bring the CTA within Congress's regulatory wingspan. Plaintiffs, for their part, argue that the CTA is a purely domestic statute, affecting only entities that are registered to do business domestically, and only requires that these entities file a report with the federal government. Plaintiffs also note the CTA does not purport to serve a treaty or international agreement. Further, plaintiffs argue that should the court accept the incidental connection to international affairs the government relies on to make its argument, that the court could run headlong into the warning the Supreme Court issued in United States v. Bond. Into the warning the Supreme Court issued in United States v. Bond, through this, which the court cautioned against allowing an alleged exercise of foreign affairs powers to trail upon states' police power. As set forth below, plaintiffs are correct. The court begins its analysis by determining whether the inquiry before it is truly one of foreign affairs. Only then can the court turn to the authority the government relies on in its response. Once more, first principles appear an appropriate place to begin. Matters relating to the conduct of foreign relations are so exclusively entrusted to the political branches of government as to be largely immune from judicial inquiry or interference. That principle makes sense as these matters involve decisions of a kind for which the judiciary has neither the aptitude, facilities, nor responsibility, and which have been long held to belong in the domain of political power. But as with each inquiry performed in this case, the court's deference in matters of policy cannot, however, become abdications in matters of law. Congress's foreign affairs powers are not expressed in Article 1 of the Constitution, other than the clauses saying that Congress may regulate commerce of foreign nations, establish a uniform rule of naturalization, declare war, raise support in armies, provide and maintain a navy, and make rules for the government and regulation of the land and naval forces. No less, although there is in the Constitution no specific grant to Congress the power to enact legislation for the effective regulation of foreign affairs, there can be no doubt of the existence of this power in the lawmaking organ of our nation. but that power is far from plenary and does not extend to purely domestic matters. Further, as the District Court from the Northern District of Alabama observed in analyzing Congress's foreign affairs powers applied to CTA, the precise contours of Congress's foreign affairs power need not be defined to determine that the CTA is in no way connected to whatever authority over foreign affairs Congress might have. This is because the CTA regulates internal matters, not foreign ones, negating an inquiry into potential political question involving the CTA. So essentially, in summary, making companies register generally is not about dealing with foreign entities, foreign governments. In matters involving foreign affairs, the government is not limited by the Constitution's enumerated powers. Indeed, the Supreme Court has made clear that the broad statement that the federal government can exercise no powers except those specifically enumerated in the Constitution and such implied powers as are necessary and proper to carry to effect enumerated powers is categorically true only in respect to our internal affairs. This principle drove the Supreme Court to hold a statute which gave the president the power to declare an embargo on foreign arms. Here, that principle demands the court answer the threshold question of whether the subject of the CTA's regulation, the anonymous existence and operation of foreign companies, is an internal, domestic, or external foreign matter. The CTA's text provides an answer. The CTA, by its very language, does not regulate any issue of foreign affairs. It regulates a domestic issue, anonymous existence of companies registered to do business in a U.S. state and their potential conduct. It bears repeating, a reporting company subject to the CTA is an entity that is either created by the filing of a document with the Secretary of State or similar office under the law of a state or Indian tribe, or formed under the law of a foreign country and registered to do business in the United States by the filing of a document with the Secretary of State or similar office under the laws of the state or Indian tribe. These entities, though special under the CTA as reporting companies, remain creatures of state law, right? Because the foreign companies are registering under state law. As the court has already noted, no principle of corporation law and practice is more firmly established than the state's authority to regulate domestic corporations. History confirms that our founding fathers believed just the same. Although the founders were aware that leaving business regulation primarily to the individual states might cause friction within the overall American economy, they were more reluctant to allow concentrations of economic power, which they visualized as a government-sponsored monopoly, and therefore chose to leave incorporation to the states. Thus here, Congress is bound by a written constitution and the enumerated powers which it provides Congress. There is scant, if any, history or precedent to suggest that whatever foreign affairs powers Congress might possess under the necessary and proper clause can reach the domestic issue of entities registered to do business under state law. The authority the government does nothing to bolster its argument. Kennedy versus Mendoza-Martinez involved the constitutionality of a statute that functioned to divest an American of his citizenship as a consequence for his draft dodging, which the Supreme Court struck down as failing to provide sufficient safeguards to comport with due process requirements. The court did not grapple with Congress's power to enact those statutes, which facially appear to derive from Congress's enumerated power over citizenship. Hernandez versus Mesa, another case that the government relies upon, involved a cross-border shooting. There, the court declined to create a damages remedy for a cross-border shooting by extending its prior precedent. Bivens versus 6 unknown Fed narcotics agents, which permitted a victim of an unlawful arrest and search to assert a claim under the Fourth Amendment for damages in the absence of a statute authorizing this type of claim. Oh, I think I combined those two. Because I missed the part, but you get the idea. Basically, they declined to create a damages remedy for a cross-border shooting that involved the narcotics people. The Supreme Court defined a cross-border shooting as, by definition, an international incident. That is very different than the monitoring of domestic entities, which is what the CTA does. At any rate, Hernandez did not contemplate Congress's power to legislate, though it reaffirmed the notion that courts should not intrude upon matters of foreign relations. Next, the government cites United States versus Dire, a case involving the constitutionality of a search of individual convicted possessing counterfeit gasoline coupons in violation of the Second War Powers Act of 1942, a matter inapplicable to this case. The government relies on it, however, not as analogous, but in conjunction with Holder v. Humanitarian Law Project to say that a legislative act of Congress is presumed constitutional and that presumption is heightened where it involves matters of national security and foreign affairs. The court does not dispute that premise. Instead, the court notes that a heightened presumption does not apply simply because the government says so. Neither does Holder suggest that it applies to the CTA, which the court has already determined regulates a domestic matter. Holder involved constitutional challenges for vagueness and under the First Amendment to a statute criminalizing the provision of material support to terrorist organizations and delegating to the Secretary of State the authority to designate an entity as a foreign terrorist organization. There's no dispute that the court is not equipped to determine what constitutes a foreign terrorist organization, but this does not contemplate that question any more than it considers a foreign issue. The court need not apply a heightened presumption to the CTA and reporting rule. The final case the government relies upon is Curtis Wright Export, or I don't know if it's maybe Curtis Wright Export Corp, to support its position that Congress may pass legislation that furthers its foreign affairs powers, as well as the president's. That case, as already established, removes the CTA from inquiry under Congress's necessary and proper foreign affairs power, as the CTA does not relate a foreign issue. Thus, the court turns the ultimate question of whether the CTA can be justified by Congress's power to regulate foreign affairs when the CTA only regulates a local matter. It cannot. On this point, plaintiffs direct the court to Bond v. United States, a Supreme Court case that is not directly on point, but is helpful in analyzing the limiting principle of Congress's implied power over foreign affairs. Plaintiffs suggest that Bond limits the scope of international legislation to exclude domestic issues. The facts of Bond are these. First, in 1997, the United States ratified the International Convention on Chemical Weapons pursuant to the federal government's power to make treaties and enumerate power. Subsequently, in accordance with the United States obligations under the treaty, Congress enacted the Chemical Weapons Convention Implementation Act of 1998, which made it a federal crime for a person to use or possess any chemical weapon and punished violators with severe penalties. Thereafter, a microbiologist from Pennsylvania discovered that her husband had an extramarital affair with her close friend, resulting in the friend's pregnancy. Seeking revenge, the microbiologist took several chemicals from her employer, a chemical manufacturer, and dispersed them on her friend's car door, mailbox, and doorknobs. Ooh, that's pretty revengeful there. The friend suffered a minor chemical burn to her thumb. For this, the government charged the microbiologist with violating the Chemical Weapons Convention Implementation Act. After pleading guilty, the microbiologist appealed, argued the Implementation Act exceeded Congress's enumerated powers. The Supreme Court overturned her conviction, held the Chemical Weapons Act did not reach purely local crimes. In arriving at its holding, the court relied on fundamental Federalist principles, remarking that because our constitutional structure leaves local criminal activity primarily to states, the court has generally declined to read federal law as intruding on that responsibility, absent a clear indication from Congress. The court also rejected an argument that the prosecution was a necessary and proper means of executing the national government's enumerated power to make treaties. As the district court in NSBU versus Yellen correctly observed, Bond involved a matter of statutory interpretation, not constitutional interpretation. The government's attempt to distinguish Bond on this basis, but no less, Bond's principle that foreign affairs powers generally may not reach local issues remains true and applicable to this case. The government seeks to justify the CTA as reaching the local issue of companies who register to do business with a particular state. Affirming the constitutionality of the CTA on the basis of foreign affairs would permit Congress to reach in the states and regulate whatever it wants, simply to point to some vague nexus between the statute at issue and a potential foreign actor. That theory stretches the fabric of our dual system of government too thin to pass constitutional muster. So in summary, you can't just use the generality of foreign affairs and foreign actors to say, oh, well, therefore we get to also regulate what happens on a local level just because, well, there maybe has some things to do with foreign actors if a foreign actor registers their company or something. Not going to fly. If the CTA is not a raw exercise of Congress's foreign affairs powers, then the government's only hope is the necessary and proper clause. Once more, in determining whether the necessary and proper clause grants Congress the legislative authority to enact a particular federal statute, the inquiry centers on whether the statute constitutes a means that is rationally related to the implementation of a constitutionally enumerated power. The government has yet to identify a single enumerated foreign affairs power that shares a nexus with the CTA. It notes that Congress believes the CTA is necessary to bring the United States into compliance with international anti-money laundering and countering financing of terrorism standards. Sorry, I losing there a little bit. But the court's hearing on October 9th, the court asked the government whether the CTA was linked to a treaty. The government responded in the negative, and the court pressed the parties on which international standards the CTA would help the United States to comply with. Once more, no party could offer an answer. In Bond, the court declined to apply a law passed pursuant to a treaty to a purely domestic issue. Here, there is no treaty, so don't even have a treaty. And while there is a passing reference to an international standard Congress may strive to comply with, congressional findings alone are insufficient to bring the CTA within Congress's necessary and proper power. The government has not provided any authority to the contrary. There's simply no enumerated power the government can identify that would justify the CTA, barring the court from affirming the CTA as justified by the necessary and proper clause. The government has not provided any support, and there appears to be no support for the proposition that Congress may legislate in arenas traditionally controlled by the states simply because it has made filings that make passing mention to an international impact. And while Congress's findings in the NDAA include reference to national security and foreign affairs and international standards, Congress cannot invoke its foreign affairs powers to regulate a domestic issue simply because it waves the magic wand of ipse dixit. Compliance with international standards may be good policy, but is not enough to make the CTA necessary or proper. There does not appear to be a single enumerated foreign affairs power to which CTA can be legitimately linked. That is fatal to the government's argument on this point. Thus, the court must turn to the government's final argument that the CTA is within Congress's enumerated powers. All right, so now the final argument that the government has the ability to do this in enumerated powers. Taxing power and the necessary and proper clause. Back to the corner with one remaining card up its sleeve, the government's final argument is that the CTA is a valid exercise of Congress's power to lay and collect taxes as expanded by the necessary and proper clause. And you might already be getting where this is going without thinking, but too much ahead, but there was no tax in this reporting requirement, right? It wasn't to pay a tax. It was just a report. So that's probably where this, at least in the limited sense, is going to go down, even though if they try to reintroduce this with a tax, then hopefully it doesn't, but it could scarily survive. But there's no tax here, so let's see what happens. The Constitution confers upon Congress the power to lay and collect taxes. The government wisely concedes that the CTA in no way, shape, or form is a tax, right? Instead, it argues that because the CTA is in aid of a revenue purpose, that is, it helps to facilitate tax collection. The CTA is constitutional as an exercise of Congress's power to enact laws necessary and proper to enforce its taxing scheme. The court disagrees. As the sections below demonstrate, this final card does not arm the government's hand with a royal flush to conquer plaintiffs' arguments. The government notes that Congress determined that the lack of beneficial ownership information allows criminals to obscure their income and assets and thus facilitates serious tax fraud. Because Congress determined that the CTA's mandated beneficial ownership reports would be highly useful in detecting tax fraud and improving tax administration generally, the CTA is a valid exercise of Congress's power to legislate in furtherance of and adjacent to its tax scheme under the necessary and proper clause. So the argument goes. Plaintiffs, in contrast, contend the government's hypothesis results in a substantial expansion of federal authority that breaks the boundaries of Congress's taxing and necessary and proper powers. The court agrees with plaintiffs, as do I. The court first turns to the four cases the government cites in furtherance of its arguments on this point, but the authority the government relies upon does little to justify the CTA as an act derivative of its power to lay and collect taxes, such that the necessary and proper clause bridge the gap to constitutionality. First comes Sosinski versus United States, which the government cites for the proposition that Congress may legislate in aid of a revenue purpose. There, the Supreme Court upheld a law that imposed a special tax and registration requirement on dealers of firearms as authorized by Congress's taxing power. True enough, the Supreme Court stated in dicta that those registration provisions were obviously in aid of a revenue purpose. But it did not determine for the ages, as the government suggests, that Congress can pass any regulation it wishes as long as Congress can point to a revenue purpose it might serve. Instead, that special excise tax, which the statute created on its face, was a taxing measure, with a consequential deterrent effect on the keeping of the particular type of firearm at the issue in that case. The Supreme Court held that a taxing measure is not outside of Congress's taxing power simply because it carries a consequential deterrent effect. And accompanied that determination, the Supreme Court did not consider the necessary and proper clause. Second, the government cites Helvering versus Mitchell for the same proposition, though the case too says nothing about the necessary and proper clause. Helvering involved the Revenue Act of 1928 as related to deficiencies on income tax returns. The act provided that if an individual's tax returns are deficient due to fraud, then the individual must pay half of the amount of the deficiency in addition to the deficiency. The question before the Supreme Court was whether this provision imposed a criminal penalty such that payment on a deficiency would be barred by double jeopardy. The Supreme Court answered in the negative and held that the provision was a tax. Thus, as in Sosinski, a tax that generates revenue is not unconstitutional simply because it carries with it some regulatory measure. Like Sosinski, Helvering does not purport to suggest that Congress may legislate however it wants because such legislation might deter tax fraud. Next, the government relies on CIC Serves, LLC versus IRS, and California Bankers Association versus Schultz for the proposition that Congress has given the IRS broad power to require the submission of tax-related information that it believes helpful in assessing and collecting taxes. Indeed, the Supreme Court in CIC Services LLC did say just that, but once more, the context of that case does not render it dispositive on the CTA's constitutionality. There, plaintiffs challenged under the APA the enforcement of an IRS notice that required taxpayers and material advisors to report information of a particular type of transaction. The issue before the court was whether the Anti-Injunction Act barred the plaintiff's suit under the APA. The answer to that question does little to answer the one that now captivates the court, other than to say that information gathering is a phase of tax administration that occurs before assessment or collection. Therefore, information gathering is separate and apart from a tax itself. California Bankers Association versus Schultz, which also does not concern the necessary and proper clause, also does little advance the government's argument. At issue in Schultz was the constitutionality of the Bank Secretary Act of 1970. Part of the act required financial institutions to maintain records of the identities of their customers, to make microfilm copies of certain checks drawn on them, and to keep records of certain other items. The Supreme Court noted that the purpose of these provisions was to compel the maintenance of reports that have a high degree of usefulness in criminal, tax, or regulatory investigations proceedings. The court did not address the Bank Secrecy Act propriety under Congress's taxing power, but instead entertained challenges in the First, Fourth, and Fifth Amendments to the Constitution. Again, this does not assist the court in assessing the CTA as ancillary exercise of Congress's taxing power. The government finally turns to United States versus Matthews for the proposition that a regulation need not be paired with a concurrent tax to be a valid exercise of Congress's power to lay taxes. But Matthews says just the opposite. The line to which the government refers fully states that if the registration requirement was not offensive when coupled with a concurrent tax, it is not offensive when designed to aid the collection of tax on any future transfer of the registered item. To clarify the context in which this line appears, in Matthews, an individual had been convicted of unlawful possession of a firearm not registered to him in a national registry as required in the Gun Control Act of 1968. He argued that the statute under which he was convicted was not constitutional because it was not an appropriate necessary aid to the reasonable enforcement of a valid revenue measure. To him, such a challenge made sense because the statute under which he was convicted did not carry with it a tax. The court disagreed, noting that there was, in fact, a tax levied against individuals who kept such firearms. Once more, just as in Halvering and Szynski, that case is just a tax that generates revenue is not unconstitutional simply because it carries with it some regulatory measure. So again, as you can see in the direction they're going here, if there's a tax with it, it could pass muster. There's no tax with the CTA, which is, again, I don't like this direction because then they're going to maybe try to repass it with a tax attached. So hopefully we get some people to stop this and stop the tax at all and stop that ability, but we'll see. Even going beyond the authority of the government cites, going beyond the government, the authority cites in its response, precedent is consistent with these holdings. In the case they mentioned, they uphold the Harrison Narcotic Drug Act that tax sales of drugs to authorize individuals, stating that the act may not be declared unconstitutional because its effect may be to accomplish another purpose as well as raising of revenue. There's also another case upholding gamblers' occupational tax provision of the Revenue Act of 1951, which levies a tax on persons engaged in the business of accepting wages and requires such persons to register with the Collector of Internal Revenue. And there's another case, National Firearms Act, and the criminal penalty for violating are justified by Congress's taxing power because a regulatory penalty coupled with an underlying tax has long been accepted as within the province of Congress's power to lay and collect taxes. In toto, these cases stand for a far humbler proposition than the government suggests. A tax which necessarily generates revenue and is not unconstitutional simply because it may carry a regulatory deterrent effect on conduct, even where the tax requires some form of registration. The government has not provided the court with a single case that suggests Congress's taxing power, even when coupled with the necessary and proper clause, can be used to regulate when the statute at issue does not in some way generate some revenue, i.e. is not a tax. Had the government cited United States v. Carringer, it may have parroted what the Supreme Court said in dicta. Nor do we find the registration requirements of the wagering tax offensive. All it is required is the filing of names, addresses, and place of business. It is quite general in tax returns. Such data is intimately related to the collection of the tax and are obviously supported as an aid of a revenue purpose. But even that would not persuade the court that the CTA falls in the purview of its power to tax or do what is necessary and proper to give effect to its enumerated powers. The judiciary operates on the basis of stare decisis, not stare dicta. In other words, past decisions, not just extra things that were just said in passing. That's the layman's term on that. Carringer, like Szynski, does not purport to suggest that Congress may legislate in an unbridled manner simply because it might make some tax someday easier to collect. In each of the cases discussed above, the challenge statute imposed a tax and had some regulatory provision or consequence. The CTA does not impose a tax whatsoever, right? So CTA has no tax, so it can't even fall into that. While a tax that generates revenue is not unconstitutional simply because it carries some regulatory measure, the inverse of it is not true. In other words, a regulation is not unconstitutional or is not constitutional simply because it carries with it an incidental tax benefit. This is a category that CTA falls under. Ooh, that's good. The cases above all have one thing in common. The regulation being attacked is attached to underlying tax. The same is not true of the CTA. And what little connection the government suggests the CTA has with the at-large taxing system imposed on Americans is tenuous at best. As Justice Frankfurter said, when oblique use is made of the taxing power as to matters which substantively are not within the powers delegated to Congress, the court cannot shut its eyes to us obviously because designedly an attempt to control conduct was the Constitution left to the states, merely because Congress wrapped the legislation in the verbal cellophane of a revenue measure. Oh, so this is actually excellent. So this court's giving a pushback on that idea of trying to, sneak in regulation with the tax because of the wide taxing power, and there's a lot of deference there. But here they're pushing back and it's saying, maybe you still, even with a tax, couldn't get this through because it's outside your enumerated powers. And so in the context of the government's argument here that Congress sensed that the CTA would be highly useful in detecting tax fraud and improve tax administration in general, do not render the CTA constitutionally valid. Thus, the cellophane that wraps the CTA is thin. Precedent indicates that prior cases upholding laws under the necessary and proper clause involved exercise of authority derivative of and in service to a granted power. The CTA is not derivative of the taxing power simply because the government points to some potential tax purpose the CTA might serve someday. Though it may be in service to taxation as a general matter, because the CTA does not derive from the taxing power, it is neither tightly linked nor rationally related to Congress's power to lay and collect taxes. So again, this is an important note to take away for future cases or future arguments. You might want to bring this to bear if you're suing over this, that even if you try to get it back in as a tax, even if the government tries to bring it in with a tax measure, you push back and say, well, just because you add a tax to this and add this regulation doesn't mean that you can add the regulation because it's not an enumerated power, and taxation can't just cover that up for you. So that would be the way you got to push back there. Told otherwise would be unleash a slippery slope that could wreak havoc in the structure of our government. It would be a substantial expansion of federal authority to permit Congress to bring its taxing power to bear just by collecting useful data and by allowing tax enforcement officials to access the data. While the government disputes plaintiff's assertion that the necessary and proper clause does not provide an independent source of power, its position stands in stark contrast to the Supreme Court's interpretation that it must be narrow in scope or incidental to enumerated power. Having determined that the CTA is not justified by the Commerce Clause nor the necessary and proper clause in conjunction with some enumerated power, the court concludes that plaintiffs have met their burden to show a substantial likelihood of success in the merits of their 10th Amendment challenge. Thus, the court need not assess plaintiffs' as-applied challenges or their challenges under the First and Fourth Amendments. Thus, the court must now determine whether the equities favor issuance of an injunction, and they do. So, very long case so far. Obviously, there's a lot to cover, but we now are at a point where the court is simply saying, just on the 10th Amendment challenge alone, which is incredible because it's so rare to get a successful 10th Amendment challenge. It is so rare. So this is a beautiful thing to see. If this 10th Amendment challenge can make it up to the Supreme Court, it would be amazing. But they're saying that this is strong enough alone, even without First and Fourth Amendments, that the CTA does not pass constitutional muster, facially. So I would say this case is something to look at and to expand upon further too. This is something to talk about later on. The government tries to do this again by adding a tax, going at it, saying you don't even have the power to do this, and a tax can't cover it. Because you basically be arguing at that point. Oh, okay, well, then the federal government can just tax anything and then regulate and then add a regulation with anything, and then there is no federalism because, well, we just have a tax and we attach any tangential regulation with it and say, "Ooh, look, we can do it now. We can add any regulation we want." So I think the way that this court's going for it in terms of limiting federal power, I think is the way to go going forward. All right, let's take a look at this balance of equities. Looks like we're almost to the end. The final step in the inquiry calls upon the court to determine whether the balance of equities favors issuance of injunction, the third and fourth factors. The third element is whether the harm posed by the CTA and the reporting rule outweighs any damage injunctive relief might inflict on the government. The fourth is that injunctive relief will not harm public interest. Whereas here the government is the defendant, those elements merge. On these facts, the court determines that the threatened injury to plaintiffs outweighs any potential harm to defendants. Without injunction, plaintiffs will almost certainly incur substantial and incompensable monetary costs and constitutional harm. When a statute is enjoined, the government necessarily suffers the irreparable harm of denying the public interest in the enforcement of its laws. Certainly, the court acknowledges the government seeks to serve admirable ends to the CTA and the reporting rule. Obviously, the government has an interest in ferreting out financial crime, protecting foreign commerce and national security, and bringing the United States' monetary laundering law money laundering laws and in compliance with international standards, whatever those standards may be, which, I don't know. But the government argues that balancing these interests against the speculative nature of the harm that plaintiffs face, the government's interest should win the day, but not so. Plaintiffs' injuries are concrete, and neither the government nor the public has any interest in enforcing a regulation that violates federal law. No matter how laudable its goals, Congress's actions must abide by our Constitution. This is in the public's best interest. Indeed, it is always in the public interest to prevent a violation of a party's constitutional rights. Because the CTA reporting rule likely do pass muster in the Constitution, it is in the public's best interest to prevent the government from enforcing the CTA and reporting rule. I was just reading that because the CTA reporting rule likely do pass muster in the Constitution, is the public's interest to prevent the government from enforcing the CTA and reporting rule. Now I'm confused because I think they mean do not. I hope that's not a problem. I think they mean do not there because the CTA reporting rule likely do not pass muster in the Constitution. Gosh, I hope that doesn't screw anything in the future. But anyway, it is in the public's best interest to prevent the government from enforcing the CTA. I think they meant to have the word not there. It's missing. All right. Due to the fast approaching deadline for reporting companies to file BOI reports, the court cannot render a meaningful decision on the merits before plaintiffs suffer the very harm they seek to avoid. A preliminary injunction will preserve the constitutional status quo. Thus, the balance of equities favors issuance of an injunction. Woo! Accordingly, the court determines that the plaintiffs have satisfied all elements required for the issuance of a preliminary injunction against the CTA and the reporting rule. Scope of injunction. Here's where it gets to be a big deal. Finally, given that an injunction is appropriate, the court must determine its scope. Plaintiffs seek injunctive relief on behalf of the individual plaintiffs as well as all of NFIB's members. The government characterized plaintiffs' request as one for a nationwide injunction. At the court's hearing, plaintiffs suggested they sought an injunction on behalf of one of the plaintiffs before the court, including the approximately 300,000 members of NFIB. The government responded that the court would enjoin the CTA and the reporting rule, the scope of which included NFIB's members, and the court would, in practical effect, enter a nationwide injunction. The court agrees with the government's point. A nationwide injunction is appropriate in this case. Isn't that kind of funny here that the government was like, hey, if you're going to enjoin against all these people, it's practically a nationwide. What are you doing? And the court's like, yeah, you know what? You're right. We should just make it nationwide. Thank you, you dumb government workers, and giving the court the idea to do a nationwide injunction just because. I cannot appreciate you more enough for suggesting that idea. All right. A preliminary injunction is an extraordinary equitable remedy. The Constitution vests district courts with the judicial power of the United States. That power is not limited to the district where the court sits, but extends across the country. It is not beyond the power of a court in the appropriate circumstances to issue a nationwide injunction. And so they show other cases where a nationwide injunction was done in an immigration context, another nationwide injunction, for another case as well. So several cases with nationwide injunctions just from a district court. And they say courts should not be loath to issue injunctions of general applicability. Not be loath as in, you can go ahead and do this. The injunctive processes are means of effective general compliance with national policy as expressed by Congress. A public policy judges must carry out, actuated by the spirit of the law and not begrudgingly as if it were a newly imposed fiat of presidium. But simply because the court may issue a nationwide injunction does not mean it should in all cases. As the Supreme Court has held, the scope of injunctive relief is dictated by the extent of the violation established, not by the geographical extent of the plaintiffs in the class. The relief the court fashions should be no more burdensome to the defendant than necessary to provide complete relief to the plaintiffs. The Fifth Circuit has approved nationwide injunctions in cases involving immigration and the APA. It has also held that it is appropriate for a district court to enter a nationwide injunction when a plaintiff challenges a federal regulation to the APA. So they have a case here when a reviewing court determines that agency regulations are unlawful. The ordinary result is that the rules are vacated, not their application to individual petitioners is prescribed. And I agree. If you're going to say, hey, this is a bad to apply, it should apply to everybody. I mean, it shouldn't just be a couple people. It's ridiculous. Nonetheless, the government highlights a controversy regarding nationwide injunctions. Nationwide relief is a subject of ongoing debate. One concern is that nationwide injunctions curtail the percolation of legal debate among lower courts. Thus, the government urges the court to tailor its self-relief to only the parties before. Because at this very moment, the 11th Circuit is considering the constitutionality of the CTA and the reporting rule. But this court's decision will not trench upon the 11th Circuit authority to render a decision, nor will stop further consideration of the Constitution of the CTA. Yeah, that's just ridiculous anyway of them saying that, because just because they have a nationwide injunction at a district court does not prevent any appeals court from also having their own rulings. You could have an injunction and then they still have a ruling. It's just nonsense. These government goons just literally just want to go after people and rake them over for money. It's just so sick. The court determines that the injunction should apply nationwide. Both the CTA and the reporting rule apply nationwide to approximately 32.6 million existing reporting companies. NFIB's membership extends across the country. And as the government states, the court cannot provide plaintiffs with meaningful relief without, in effect, enjoying the CTA and the reporting rule nationwide. The extent of the constitutional violation plaintiffs have shown is best served through nationwide injunction. Given the extent of the violation, the injunction should apply nationwide. Plaintiffs also urge the court to enjoin the reporting rule, which instructs courts to hold unlawful and set aside agency action found to be contrary to constitutional rights. Such vacatur is the default rule in the circuit. But Section 706 is not the proper vehicle to protect plaintiffs from irreparable harm at this juncture. The court has determined that the CTA and reporting rule are likely unconstitutional for purposes of a preliminary injunction. It has not made an affirmative finding that the CTA and the reporting rule are contrary to law or that they amount to a violation of the Constitution. Thus, the court determines that the government should be enjoined from enforcing the reporting rule, and the January 1st, 2025 compliance deadline under the reporting rule should be stayed until Section 705 of the APA. So, again, they're just saying here, I think it's just important to note, they made an affirmative finding of the CTA and the reporting rule that they're contrary to law. So they're not making that final rule saying, oh, it's unconstitutional. Remember, this is just an injunction. It's just saying, hey, you can't enforce this from now because they're likely to win and it could be serious harm. So this isn't them striking it down outright yet. It's just saying, hey, for now, you can't enforce it until we actually get a solid ruling. The court saying, hey, this is actually unconstitutional or constitutional. Hopefully, unconstitutional. I think it's pretty clear at this point between, this court in Alabama that it's definitely unconstitutional. Under Section 705 of the APA, the reviewing court may issue all necessary and appropriate process to postpone the effective date of an agency action or to preserve the status or rights pending conclusion of the review proceedings to the extent necessary to prevent irreparable injury. We have the power to stay the agency's action to the extent necessary to prevent irreparable injury. The Fifth Circuit has interpreted this provision of the APA as akin to a preliminary injunction. Thus, the court may grant relief under Section 705 using the same four-pronged test as the court uses for a traditional preliminary injunction. Having determined that plaintiffs have satisfied each of the four elements for a preliminary injunction, a stay of the reporting rules compliance deadline pending further order of the court is appropriate. Just as the injunction against the informant of the CTA should apply nationwide, a stay of the reporting rule should apply nationwide. Nothing in the text of Section 705 nor of Section 706 suggests that either preliminary or ultimate relief under APA needs to be limited to the parties before the court. Instead, the scope of preliminary relief under Section 705 aligns with the scope of ultimate relief under Section 706, which is not party restricted and allows the court to set aside unlawful agency action. A stay coupled with an injunction against enforcement of the CTA and reporting will remain the status quo and protect the parties from irreparable harm. In conclusion, plaintiffs have satisfied all prerequisites for a preliminary injunction. The court has authority to issue the injunction plaintiffs seek under Federal Rule of Civil Procedure 65D. The CTA is likely unconstitutional as outside of Congress's power. Because the reporting rule implements the CTA, it is likely unconstitutional for the same reasons. The court has not addressed the issue of CTA's unconstitutionality as applied to the plaintiffs or plaintiffs' challenges under the First and Fourth Amendments. Having determined that plaintiffs have carried their burden, the court grants plaintiffs' motion for preliminary injunction. Therefore, the CTA 31 U.S.C. Section 5336 is hereby enjoined. Enforcement of the reporting rule 31 CFR 1010.380 is also hereby enjoined, and the compliance deadline is stayed under Section 705 of the APA. Neither may be enforced. The reporting companies need not comply with the CTA's January 1st, 2025 BOI reporting deadline pending further order of the court. Federal Rule of Civil Procedure 65C provides that the court may issue a preliminary injunction only if the movement gives security in an amount that the court considers proper to pay the costs and damages sustained by any party found to have been wrongfully enjoined or restrained. The Fifth Circuit has held that district courts have discretion to require no security at all. Ooh, that's nice. After considering the facts and circumstances of this case, the court finds the security is unnecessary and exercises its discretion to not require plaintiffs to post security. It is therefore ordered that plaintiffs' motion for preliminary injunction is hereby granted. It's so ordered. Wow. So that was a really long injunction order, but hopefully now that you've heard this all, this was a lot to read, so appreciate your bearing with me with some of the chokes and slurps in here going on back and forth, but reading a document for 2.5 hours is quite draining on the vocal cords. So in summary, right, this court here, this district court specifically, I'm going to pull all the way back up, the Eastern District of Texas, Sherman Division, they enjoined the federal government from applying the reporting rule for the Corporate Transparency Act, and basically laid out a very strong case that, this is going to be considered unconstitutional under the 10th Amendment alone, and that the CTA, it has no tax even tied with it, so it doesn't even fall under a taxing ability. It has no nexus to foreign affairs things, across the board, whether it's the Commerce Clause, because, against the corporation rules themselves, the reporting rules have nothing to do with, people moving in commerce or goods in commerce. There's just literally no avenue that this rule falls under any type of special exception or any type of narrow thing. And the court actually gave a really great avenue to attack this further should the government try to pass it as a tax. If the government tries to say, well, we'll just repass this, but say it's a tax and you have to report, they can simply say that this isn't an enumerated power, that, the corporate forms are creatures of the state, and this is going too far. It's basically destroying federalism, and it would basically almost say that, well, the federal government could just make any tax and add a regulation with it, and boom, now they can do anything. There's no, this is limited to the federal government. This is limited to states federalism. So this is an incredible injunction, really something to read and learn from. Incredible histories on, the Commerce Clause, necessary and proper clause. It's a very informative case to read about and to study and to look at, and especially if you're going to be, involved in this or litigating on this, something you're definitely going to have to, know and bring to bear as you're bringing it up, through these courts. As they mentioned, the 11th Appellate Court, that's the 11th Circuit, is going to be hearing a case, basically, on the same issue. This also, was first brought up in Alabama, and then it was brought over to that 11th Circuit, and the Alabama court also gave an injunction, but that one was limited only to those parties, whereas, when Texas is nationwide, which is wonderful. Everyone should be protected from this huge invasion of privacy, this huge growth of federal power, which would just be absolutely insane. So I hope you enjoyed this video. Again, it's just an informational video. If you need legal advice, go seek an attorney in your jurisdiction. But hopefully this at least is good news, and it continues to be good news as courts up the chain continue to strike this down and affirm that this is just totally unconstitutional. I really hope it does make it to the Supreme Court, and that they make a 10th Amendment ruling, because that would just be wonderful and landmark, and just to push back on the Commerce Clause and push back on necessary and proper using 9th and 10th Amendments would just be absolutely astounding and incredible to see. So thank you so much, everyone, for hanging out, and I'll talk to you again soon for more case coverage on law, liberty, and logic.